Lordship, may I permit to mention a matter? May I permit to mention a matter?
Please not the mentioning date.
Your Lordship, the similar circumstances matter is fixed by your Lordship on 30 in connection with upper primary 2016 selection process.
Tell us when it is taken up. Please not the mentioning date. Yes, call the list.
My lord, may I be permitted to leave to file, my lord, without satisfaction?
When was the order passed?
Order, my lord, on 22nd, my lord, but it was uploaded yesterday evening, my lord,
22nd
of January.
What is the urgency?
Urgency, my lord, despite, my lord, he has no local standing, my lord, to prefer any petition, my lord. He has.
What
been
is the
allowed,
urgency? Urgency.
my lord, ID password to be.
Pardon?
ID and password to be given. That is the urgency, my lord. He has no local standing, my lord.
ID and password to be given. What is the problem then?
My lord, to whom, my lord, ID password has been given to directed to give, my lord. He has no locus standi, my lord. That is my urgency.
You are for the commission or
Yes,
board?
my lord, Madrasa board.
Madrasa board. Oh. Direction has been given to issue password and ID
Yes,
in
ma'am.
favor of the writ petitioner.
Yes, my lord.
By when?
By, my lord, today. And yesterday evening, my lord, it has been uploaded, my lord, the order.
Leave that.
I'm grateful.
Yes, call the list.
My lord, I'm for the appellant. It's a leave to appeal.
But in item number 2, my lord, I like to intervene, my lord. I already filed send my clerk to file the application. It's ready.
What application?
Application for addition of party. Because the order which was passed initially by the Honorable Single Bench, in that
Well,
matter,
I am appearing for the board.
but since I was not a party in the present writ petition, which is the order impugned before your lordship, I filed an application for addition of party. But
Well, I'm appearing for the board, my lord. I am taking entertainability of the application for leave to appeal. The preliminary point I am taking, my lord.
Then my lord, kindly take it up day after tomorrow, Thursday, madam.
Come on.
Friday ball.
Friday.
Thursday to kal
Friday.
Friday or Monday?
It's better, my lord, take it up on Monday.
Let it be on Friday.
My lord, kindly take it up on the Monday, my lord. Mr. Sandlal will be not be available on Friday, my lord. Your lordship. Kind concert.
Monday.
Obliged.
Grateful, my lord.
Much well.
Monday. Oh, Monday.
Then my lord, kindly take it up tomorrow, my lord.
Third will be a problem for you.
My lord, interview, my lord. We are praying for participation in the ongoing interview process, my lord.
All right, Friday. Yes.
Of-
ওই applicationটা নিয়ে আসবে। Application.
I'll filing it back.
I'm deep down, sir.
No, interview is, my lord, going on, my lord. It is not that
On
the
Friday.
third will be
Will
completed.
Will be there. Yes, call the list. Call the list.
My lord, I am for the appellant. I couldn't serve the memo of appeal and stay application upon the learned GP within the stipulated periods. So office is refusing to accept the service. Kindly place an appropriate order so I can serve upon the GP.
I am for the school authority. I am for the school authority, man.
You are for?
School authority, I am.
I am
I am for the
appellant.
school authority.
Not sure.
What is the defect?
বলো আবার।
I couldn't serve the copy to the learned government leader within the stipulated period, as there were some defects.
27 December the appeal was filed.
Man,
Today we are in 28th of January.
there was some defect in the Wakalatnama which has since been rectified.
Rectified.
8 তারিখে ছিল।
Then where is your affidavit of service? Why did you mention, sir, when the service is not complete? Next Thursday করে দাও। Fifth, sixth, fifth.
With respect to item number 4, Miller, item number 4, Mr. HON'BLE Bari, he's on leg, Miller, a short pass for Miller kind. Item number 4.
Pass over.
Short pass. Mark.
Hey, item number 5. But I appear for the respondent writ petitioner.
He's opposing you.
There's some Mr. Shambhuddha Dotto and Suman Sengupta. They are not coming in this matter for more long time.
No one appears on behalf of the appellants.
The opposition was directed by Lordship to be filed by 9th of January 2026. They have given it on 22nd of January, my lord, on the day of closure of High Court. And now, my lord, I was given 2 weeks time, but I don't know whether they can give it that way because the court's leave was expected to be taken when they failed to, my lord, comply with the direction of court. In any event, my lord, I have received it. I should be giving 2 weeks time, my lord, because the school is lying closed. Therefore, I am to consult the school. Appellate, my lord, 6 and 7.
Petitioner, my lord. My opposition.
You are for the appellate.
I am for the appellants.
I'm for the
In the state,
petitioner
as they
respondent.
say, they filed the, they are a writ petitioner respondent.
We granted a stay order.
Yes, interim order has been granted. The 31st of January. Till 31st of January, that was the 12th of December's order. First page, second paragraph.
Stop the learned advocate appearing for the.
Yes,
You are Mr. Basu.
I am Mr. Orkonondi.
For the writ petitioner respondent.
Writ petitioner respondent, my lord.
The learned advocate appearing for the writ petitioner stroke respondent number 1 files the affidavit in opposition. Let the same Find out who is your other side.
Well, item number 8, HON'BLE Mr. appear for the matter appellate. I am praying for ordering up to date. But I am to discuss this one. HON'BLE Mr. appear for the appellate.
Yes. Item number 8.
So in the meantime, Lordship, one judgment has been delivered by your Lordship on the ground of the section 5. My section 5 application 352 days delay. That is why we want to go through this judgment, Lordship. That one has been taken and the delay has not been gone. And dismiss this section 5. A few days ago, Lordship delivered the judgment.
Mr. Dotto, you want to file any opposition? Or we allow the section 5?
Well, the delay is, I think the delay is
364.
364 days, but then opposition needs to be filed.
Yes. Mr. Dotto.
Default Millet, I was in court number 1. Kindly Millet.
Who is your other side?
Sudipto.
Sudipto.
Vikram Banerjee.
Mr. Vikram Banerjee was appearing
Yes,
the
yes,
matter. I have
We'll inform.
communicated my lord, he's come.
Bring him.
Bring him.
Yes, next.
রেস্টোরটা করে দিই অন্তত।
হ্যাঁ, বলে দিচ্ছি না। করে না।
9.
যেটা ডিসমিস ফর ডিফল্ট করলে না, ডিসমিস না করলে এরা আসবে না। সিক্রেট সেন্স অপোজিশন ফাইল করেছে কিনা জানি না।
For the appellant in this. Yes. My affidavit in reply. This is a hard round of litigation. Draw your lordship's attention to the order impugned.
Yes, what is the matter?
Yes. But this matter, parting to transfer.
Have they filed their affidavits? Both state as well as the commission?
No, my lord, I have not.
No, there was twice opportunity was given. So they chose not to file. State has filed.
Reply you have given?
Yes, I've given reply. Well, it is only that 3rd January notification issue. It is only limited to that. But my case is squarely covered, even factually, by the Gokul Chandra Malik's case. The lordship kindly takes the impugned order for once.
Yes.
Yes. My lord, in nutshell, my lord, what happened? 3rd January notification, in an usual manner, the concerned DI forwarded to the schools seeking alternative arrangement, but no step was taken. So finally, when it is 3rd round of litigation, previously your lordships passed an order in previous round of litigation. So my lord, what happened? The Honorable Single Bench in paragraph 12 of the impugned order held that since the DI had made communication, therefore the respondent number 4, the DI, is required to take further steps in terms of government notification dated 3rd January 2022. And the respondent number 4 is directed to issue fresh memorandum requesting all the neighboring schools situate around the present school of the petitioner.
Where are you reading?
Well, the impugned order, page 206 of the application.
Yes, in the event any teacher is found.
Yes. Now, my lord, kindly see there are previous rounds. My lord, kindly come to page 136 for once. That is the status. 136 of the stay application. Lordship will find that that right hand side single subject teacher on that ground, it was not allowed.
Right. Now what is the problem?
I'm coming. My lord, then my lord, it was challenged at page 191. This was challenged previously. The Honorable Single Bench was pleased to dismiss the writ petition on the ground that the portal was suspended temporarily. Then it was assailed before your lordships. Kindly take your lordship's order at page 193, where in detail your lordship had dealt with the issue. Page 193. Order of this Honorable Bench.
Yes.
Can't place it with your lordship.
Operative part, operative.
Yes. Operative part, my lord, is page 195. The fourth paragraph onwards, in view thereof.
Who was the respondent number 6?
6 was the DI of schools. In view thereof, the order impugned in the present appeal and the remark of the teacher in charge. আগে writ petition. এটা না, তুই যেটা পড়ছিস সেটা। না না, এটা আগে writ petition.
What was the observation in 9 July 2022?
That is, my lord, that is the schools. The 9th July is page 136, single subject teacher. Yes, it was the school's observation. Respond number 6 was school. Page 136, observation. Kindly take 9th July, top.
Yes, single teacher.
Single
So
teacher.
that was set aside and was directed to consider.
Yes, directed to consider, my lord, in light of 3rd January notification. Your lordship directed that.
Yes, then what happened?
Then, my lord, what happened? Kindly take page 197. Page 197. After that, my lord, the operative portion is that no, my lord, from the 3rd paragraph onwards, your lordship can consider page 197. Now, upon going through the papers and the documents provided by the petitioner and considering her submission in light of memo number 10 AC, January, that is also wrong. Wrong memo has been referred to. The undersigned does hereby opine to take urgent steps for search for a
Yes, then what happened?
Then what happened, my lord? This inaction, after this, no step was taken. We came before the honorable single bench. And
What is this 24th August 2022, page 198?
198. This is an internal memo which was circulated by the DI to other schools in search of other teachers.
Now, then what happened?
No step was taken. Then we challenged this inaction before the honorable single bench. Honorable single bench passed the impugned order, which is assembled before your lordship. Now, the honorable single bench was pleased to observe that since, if your lordship takes the operative portion at page 206, paragraph 11 onwards. Paragraph 11 onwards, if I may place it before your lordship. Here, in the present case, it is found from memo dated 12 July 2024. Respond number 4 took steps in terms of government notification dated 3rd January 2022 in search of finding a teacher of neighboring school who can man the post of petitioner after her transfer. However, memo dated 24th August 2022 was issued prior to the order passed by the Honorable Division Bench on 16th of May 2024. Therefore, the respondent number 4 is required to take further steps.
Where is this 24th August? 22?
24th August. August. 24th August is the memo as mentioned in the memo I shown to your lordship. That is,
But where is that memo?
Memo has not been given. It has been referred in the DI's communication, which will be evident from page number.
That we have seen, but what was stated in that memo?
That memo was not given to us. It has only been referred to.
Now, what did the judge say?
The Honorable Single Bench
prior to, therefore, is required to take further steps in terms of directed to issue fresh
memorandum requesting all the neighboring schools situated around the present school of the petitioner and to find out a teacher who can be deputed on the post of the petitioner in case of petitioner's transfer. Such exercise shall be completed by the respondent number 4 by 4 weeks from the date of communication of this order. In the event teacher is found from neighboring school, immediately steps shall be taken for transfer on the petitioner in terms of government notification to the 3rd January 2022. Now that was there. My lord, it has been,
how you are aggrieved?
My lord, it is put in a limbo, basically. It has been put in an infinite loop now. It is going on since 2022. This is going on. This is 4th round of litigation, finding teacher. It is going on and going on. This has been categorically dealt with by the coordinate division bench clearly by explaining the 3rd January notification and what is the duty and obligation of the DI to
that Gokul Chandra.
Gokul Chandra. Kindly take paragraph 6, 10, 11, 12. The clear view taken by the honorable division bench that it can act clearly it has been. Kindly take paragraph 6, 10, 11, and 12. 6, 10, 11, and 12. The operative portion, my lord. These 4 paragraphs. Paragraph 6 reads as an equilibrium is sought to be made between the rights of an incumbent seeking transfer and the education to be imparted to the children for which the said notification dated 3rd January 2022 was issued so that the object and purpose entrusted upon the
And
government.
what happened on the basis of this order?
Basis of
In Gokul, was the person ultimately transferred?
that is a separate matter. I came to know that he has been transferred. It has been followed in other matters. My clients have also been transferred from this order. When I came in the writ petition or the
After a willing teacher was found?
no, that was never after. It is always previously.
So show us one instance how did the DI deal with it?
I can right now give the names. I do not. I have the
No,
recommendation.
the thing is, we have said that willing word is not necessary. So as per 3rd January, now a positive step has to be taken by the DI. He has to pick up a person and depute it. So this must have been the process in your matter and others matters in view of Gokul. So can you furnish any such order to us so that we can direct him on the premise of that order which was passed?
I have the recommendation of, letters of those candidates.
No, just we are asking you, suppose after this sort of orders are passed, matters are kept in the bucket since no willing teacher. But pursuant to this order, there are cases where DI has done. And when DI complied, he must have passed an order in that I am picking up that person and show us that.
My lord, that is in respect of particular teachers of particular schools. I cannot have access to those documents of those candidates.
We
I
are
only have the
asking you that what is the thing? 3rd January local arrangement. Local arrangement is not required to be banking on a willing teacher. That is what Gokul said.
Gokul said much more than that. Gokul said that you cannot keep a transfer application pending since 2022.
Right.
Even if you do not find, and you have to give transfer, and then you make all arrangements according to 3rd January notification. Your lordship interpreted Gokul in other matters, Rupak Dhua and other matters, your lordship interpreted, and your lordship added one expression that the resultant vacancy is to be filled up. Now, following your lordship's judgment, the Honorable Present Single Bench has held that irrespective of the fact whether alternative arrangement could be made or not, it is to be given effect to.
Where is that?
Amitabh Palta.
Now that order has been complied.
These orders are being complied with.
So in compliance, the DI must have passed an order.
That is in respect of particulars. Those documents are not with me. Now, my lord, the alternative arrangement is a subsequent process. First, the transfer has to be given because 3rd January nowhere says notification that if first you find, then you leave. Kindly see, Amitabh Pal has been explained, referring to your lordship's judgment of Rupak Dhua. Rupak Dhua's judgment Rupak Dhua passed by your lordship. Gokul was also referred. Rupak Dhua was also referred. Paragraph 6 is very important, my lord, where it has been observed. অমিতাভ বলেন একটা কপি আছে
সিঙ্গেল বেঞ্চ
Where is Rupak Dua?
This is Rupak Dhua, your lordship's judgment. মিতালির ভেতর পাবি
Yes, Mr. Dotto, we asked you to talk with the principal secretary regarding these issues. Did you have the opportunity?
First day he was not available. Second time he said he will call me back. I'm waiting.
May I just request your lordship to take only 2 paragraphs of Gokul. It is very important. Your lordship kindly takes Gokul's these 4 small paragraphs, my lord, I want to place before your lordship.
Resulting vacancy এটাকে এইসব অর্ডার দিয়েও কিছু হচ্ছে না। complied with.
Amitabh Pal is, my lord, I did not get hold of this person, my lord. He has not contacted me.
No, Mr. Lahiri, what we are wanting to know is 3rd January says local arrangement. It does not say of willingness. So on the basis of that, we made an observation that you cannot keep it in abeyance for an indefinite on a pretext of non-availability of a willing teacher. You have to take the decision. That is exactly relying upon our judgment the single judge has said. Now, on the basis of that, there are instances where the respective DIs have complied. You are saying that. Now, in compliance, they must have dealt with the issue and placed the order, because what is 3rd January? If he cannot make such arrangement, he has to report it to the director,
Commissioner of School Education.
to the commissioner, so that the issue can be sorted out. We want that sort of a step taken by the DI in similar work. If you can show that to us, we can issue a mandamus saying that you act in this manner.
Lord, my respectful submission before Lordship is that how the DI has made internal arrangements, those are not given to the candidates. We only received the recommendation letter.
No, that is your argument. Now, this transfer has to be on the basis of an order of the DI. DI is the person to make local arrangement.
That is after my transfer. That is my respectful submission. Everywhere Gokul Chandra also held that, your Lordship held that, single bench also held that.
We held cannot be kept in abeyance for not getting a willing teacher.
And the resultant vacancy is to be filled up. Resultant vacancy means after he leaves, when the vacuum creates, that is to be filled up. That is also 3rd January notification.
So we have to ascertain result. You are saying that first transfer me,
yes,
let whatever be done about that vacancy.
It is to be done by the
It is to
DI.
be done. It is to be done simultaneously. Simultaneously. If you read the entire judgment,
yes,
it is this understanding, this arrangement has to be simultaneous, so that the students do not suffer.
Yes, absolutely correct, my lord.
So in effecting that, DI was insisting that if I don't find a willing teacher, I cannot make that simultaneous arrangement. Issue is finding a person to be deputed.
Yes.
We cannot, the judgment has to be read in its entirety. We said that willingness cannot be a precondition for local arrangement. You have to take the decision that Mr. X is working here, I am putting you here, you are in group such and such, you will be here for a temporary period. So that gap needs to be bridged, otherwise these litigations will follow.
My lord, my respectful submission before your Lordship.
What you are trying to interpret that the person concerned will be transferred. The post shall remain vacant. Yes. And DI in that circumstances will go on finding the teacher who will work in the school. You read that 3rd January memo.
Notification.
3rd January notification, yes. Read.
Yes, my lord. Kindly give me a moment.
Page 175.
Yes, my lord. Page 175, my lord. I'm placing, my lord, the last paragraph.
In that event.
In that event, a single subject teacher makes application.
Makes application for transfer.
For transfer. The SMC School Managing Committee will not reject the application and inform the DISE about such application. The DISE will immediately discuss the matter with the Commissioner of School Education. In the DISE will take urgent step in time-bound manner to search for a teacher on the same subject from nearby and make local arrangements so that the teacher of the other school attends the school wherefrom the teacher has applied for transfer on days of the week on a temporary basis till such time a permanent teacher's subject joins. The DISE will inform such arrangement to the CSE, who shall inform the matter to the chairman of commission, president of board and school education department. CSE will ensure such arrangement in 7 days. Immediately, the DISE will communicate such arrangement to the school concerned and the HOI will forward the application of the teacher to the DI. The DI will then forward the case to the commission consideration. Commission will suitably recommend the case for the transfer of the board, and the board will issue the transfer.
Legislature has used this word suitably recommend
Yes,
after narrating what is required to be done,
Yes, yes,
then says,
yes,
then suitably recommended the case for transfer.
yes.
So it is not in case of a single teacher, since he has placed an application for transfer, he will be transferred. The post will remain vacant.
Exactly, exactly, my lord. That is
And
my
DI will go on searching the suitable accommodation, suitable alternative.
may I just, my lord?
For 2 years, 3 years, the school will run without any teacher.
That is not my humble submission, my lord. My humble submission is it clearly says in time-bound manner, DI has to make an arrangement. My
Now,
lord,
that does not mean, try to understand what my brother. The object of the circular is to remove the regard of a single teacher. Single teacher, previous policy was that cannot be done. Now the circular came. Circular says can be done, subject to a local arrangement. When this came up for interpretation, Gokul said, by the text of that circular, you cannot keep a claim in abeyance for an indefinite period. You transfer. You take the decision, pick up a person and put him there.
Exactly.
What you are arguing as, irrespective of the fact whether the resultant vacancy will be filled up or not, you have to first transfer me.
My submission is temporarily filled up, not permanently.
Right, right.
My submission is that.
You are right. That
Temporary,
there
yes.
cannot be a vacuum.
Absolutely.
So, if you say that once it is directed that single teacher is permissible, local arrangement to be made, you cannot clarify such local arrangement on a pretext that I am not finding a willing teacher.
My lord.
This process has to go simultaneously.
My lord,
That was the object of
I bow down to your lordship's observation. That is kind. That is why I'm placing Gokul for once. Kindly take Gokul 2 paragraphs.
So we have seen Gokul.
Gokul trace on the word time-bound manner.
Yes.
The use of the word time-bound manner. So, in action, citing the reason that I am not getting any suitable alternative, and he is killing the time, that would not be permitted.
Exactly as happened in my case.
And hence Gokul says that do it within 4 weeks.
Yes.
Time-bound manner.
That is my case also.
And in that case, Rupak suggests a willing teacher, so that DI cannot take any plea that I am not getting any willing teacher.
That is exactly.
You
the
will
issue
not
of PDI.
wait when willingness will be given or not.
Yes.
You force the teacher to go.
Yes.
Okay, that willingness I am not getting, none is giving with his willingness, and hence transfer application is rejected. It would not be. It would be the transfer orders shall not be considered subject to the willingness obtained from a teacher from nearby school. This judgment says.
There is this problem.
Now
yes. This problem is all over the state, leading to multiple.
Now
DI has to take
kindly take the affidavit in opposition for once. Now kindly see what DI has done. Exactly what the Gokul has referred this matter, that you cannot issue letters after letters and say that I cannot find an alternative. My case is to that extent only. I am not going beyond it. I am only restricting myself within Gokul Chandra Malik. Kindly see what DI has done.
So what do you expect us to do? We will say that give him transfer irrespective of the post being filled up. Do you want us that interpretation? Then
my prayer is very innocuous and humble before your lordship. My prayer is that you do not hold me back since 2022. I am struggling for 4th round of litigation. From 2022, 4 years have passed. On that pretext of not finding a temporary arrangement, you do not hold me back. You make the temporary arrangement in time-bound manner and you leave me.
No. That has to be simultaneous, Mr.
Simultaneous, that's what I'm saying. Maybe, my lord, 4 weeks or 8 weeks time is set by your lordship. In between, that temporary teacher may come, and after that I may go. No.
Right. By this order which have been impugned, that is exactly what the single judge said. That you make this local arrangement by deputing a teacher. It has been said on the flip side. It has said in the event found, you do it.
Now this in the event somehow brings the ineligibility, ineffectiveness of the DI in not being able to make the
file contempt.
It is not happening since
You have to file contempt, Mr. Lahiri.
Kindly appreciates. Kindly take the next page.
Mr. Lahiri, you are arguing a thing. You want transfer. Your goal is to be transferred. How you can effectualize them? The remedy is not appeal, because the order in its totality does not say that DI is sleeping for not getting a willing teacher. On the contrary, the single judge has said that in the event that a person is found, that is responsibility is fixed, sort of responsibility fixation. Pick up the person.
Yes.
If you go in contempt, court will ask the DI to come.
My lord,
That how you have taken the
my lord, my personal experience, I have dealt with these matters. That is not
your
the view.
personal experience
It's
will
not
not.
view of the honorable
No,
single.
no, this division bench cannot repeatedly pass orders which are not to be complied with.
No,
It has to come to a particular, we cannot exercise contempt.
absolutely. My lord, kindly appreciates one thing. It says the single bench's order says in the event teacher is found.
So what modification you want,
Only
you tell us.
modification, my lord, kindly fixes a timeline that within that period of time, let an alternative temporary arrangement may be made. And after making that temporary arrangement, I may be allowed to go within that 8 weeks.
4 weeks that has been given.
This in the event teacher is found. If it is not found,
The exercise will be within 4 weeks. Exercise includes paragraph 15.
I tell you, Lordship, why it will not happen. My lord kindly appreciates. Previously, there is a Lordship, similar order is there. Your division bench's order is there. Despite that, the single bench has passed this order. Now it is going on in loop. My lord, I request your Lordship to take the affidavit in opposition once. What they have annexed.
এই এক্সারসাইজটা করতে গেলেই তো টিচারটা আসবে। প্যারা 15টা হ্যাজ টু বি রেড উইথ প্যারাগ্রাফ 14। এক্সারসাইজটাই যদি না করলো
তাহলে তো আসবে না, কিন্তু এক্সারসাইজটা যদি এই প্যারাগ্রাফটা এইখানে চলে যাচ্ছে, ইন দ্য ইভেন্ট অফ
opposition.
Yes. First, my lord, take the reply. My lord, kindly take the affidavit in reply, page 12. Kindly see the present status of the school. She is now even not even required in the school. Huh? Yes, she is now surplus. Kindly see. Kindly see. One notice communication was issued on 31st of July by the SI of schools of that school itself. All concerned are hereby page 12. All concerned are hereby informed that Bhuvankhali Junior High School under Pultoli South is currently facing an acute shortage of teaching staff Despite having an enrollment of approximately 147 students, the lack of adequate faculty is severely hampering the delivery of quality education. In contrast, Chuprijhara K. Para Junior High School, the petitioner school, presently has a surplus of teaching staff with 4 appointed teachers for only 25 active students. In the interest of rationalization and ensuring equitable access to education across schools within the same Gram Panchayat, interested teachers from Chuprijhara K. Para Junior High School are hereby invited to apply for deputation service utilization to Bhuvankhali Junior High School on a temporary basis as per decision taken in the ad hoc committee.
That is neither here nor there.
Yes, that's what I'm saying, that in my school I am
What is the stand of the DI in the
Yes. Kindly take the affidavit in opposition for once.
Yes.
Why I am submitting that this loop is going on constantly. Kindly check, Mala. The opposition. Page number 8. This is after passing the order of the Honorable Single Bench. Kindly see, in terms of, this is 26 August 2025 order, in terms of the notification dated 3rd January 2022 and memo number such and such dated 22nd September 2021, the undersigned is to inform you that the Koel Mitro, assistant teacher of mathematics subject of such and such school, has applied for general transfer as a single teacher in a single subject. According to the extant rule, local temporary arrangement of assistant teacher of same subject from the nearby school who will take classes in place of the applicant during interim period is essential. From available record, your schools have been identified as the available nearby schools, and hence you being the HOI of the same is requested to state whether the assistant teacher with same subject and same section is available with your school, and if available, express your opinion regarding the viability of such arrangement from your schools. Your clear response, either in affirmative or negative, should reach to this office within 5 days of the issue of this letter, positively through return mail. If your opinion is in affirmative, then send also the letter of consent from your end and also teacher concerned immediately. This is just a replica of the previous letter. This letter is coming every year, one after another, but my transfer is not being done. This is for temporary arrangement.
Tell me.
Similar letters were issued that give me vacancy teachers, whether you can manage. That has been addressed by the Honorable Coordinate Division Bench in Gokul Chandras, that you cannot hide behind these letters. You have to make arrangement. But kindly take paragraph 6, 10 and 11, 12 of Gokul. It has been referred of one letter dated 24th of October. The similar situation came up. Kindly take paragraph 6. My lord, I have already placed that I'm still placing for
The application cannot be kept in abeyance for until a local arrangement is made.
Lordship,
So if we clarify, if we modify the order saying that you make the local arrangement in a time-bound manner within a period of 8 weeks, then the consequence will be it has to be simultaneous.
yes,
What you are asking us is to say something which is not in the circular. It has to be simultaneous.
bow
You
down.
cannot urge that come what may, you transfer me. This cannot be the.
It's not my submission, my lord.
So today, if we modify the order saying make this time-bound manner local arrangement, in now the rider in the event it is found that will stand merged in that order which we will be passing. Now suppose after our order, DI will again come and say I am not in a position to make a local arrangement due to scarcity of teachers.
Well, here comes my submission, my lord. DI, since it's a temporary arrangement, DI has the power to bring another teacher at his place, her place, and to allow her, as per the 3rd January notification I am submitting, it is clearly given that in time-bound manner, when the notification, the statute says that in time-bound manner you have to make an arrangement. There must be some reason statute, this is legislative intent to bring an alternative teacher for a temporary period. Then the part discussion with the commission and with the board starts for filling up the post permanently. So I am only aggrieved to the extent of this temporary arrangement.
That's very good.
Yes.
Think about the person who will be brought. In terms of this order, local arrangement made, Mr. Lahidi is asked to serve in the school as a temporary measure.
Yes.
How long will it continue? State is not appointing teachers. So what happens to that person? Tomorrow you may be getting a brief from that person. Then your argument will be, how long in the local arrangement, please, you can keep me in this position. I have a family. I have to earn something. Wherever you place me, I have to go. But you are taking away you are altering my condition of service. Because nowhere in the appointment of teacher, it has been said that subject to local arrangement which can be made. Try to visualize this in there.
My lord, I am only taking the benefit of the statute. I am going by the statute law made by the state. Failure on the part of the state cannot bind me because it is incident transfer is incidental to service. Law permits it. If they cannot arrange it, that is their failure. That may not bestow upon me. On that, my respectfully I submit. And my lord, there are occasions when teachers are sent on deputation. It is not absolute right that he will stick to that school forever. If it is sent, my lord, kindly appreciate the rationalization policy. The lordship has considered that 10C rationalization. Teachers are sent for rationalization from one school to another school, where there is scarcity of schools. That exactly what your lordship found from the affidavit in reply, that since that school is required teachers, kindly come and teach there. So there is the provision. They can do it. It is within their power. That is why 3rd January notification has been contemplated in that fashion. And it cannot be, a statute cannot be made conditional at the discretion and non-compliance of a state authority's obligations. But in that case, 3rd January notification becomes optional. Then if DI cannot make arrangement, then 3rd January statute is optional. My lord, in my respect,
The legislature did not undertake to fix the time. And it has left to the judiciary to fix.
There has to be reasonable time. I have crossed.
Now we are considering whether fixing of 8 weeks to find whether it will be sufficient or not.
4 years.
The legislature just has used time-bound manner.
Yes.
What will be the time-bound manner? Whether it
Reasonable
is
time,
8 weeks, 10 weeks, 12 weeks, or 4 weeks.
I have crossed 4 years in
It is
between.
that now judiciary to fix it,
A reasonable
considering
time.
the facts and circumstances of the
Yes.
court.
A previous matter, Justice Sen's division bench, my lord, as his lordship then was fixed 6 months' time. There are instances where Justice Sen's division bench fixed 6 months' time.
Yes.
That you do it in between.
Judicial discretion.
Yes.
Now it is left to the discretion of the judiciary.
That's why I have come before your lordship, my lord.
Yes. How can you segregate local arrangement and finding out a teacher? These are inextricably bound. Local arrangement can only be made if a teacher is found.
Yes. Yes.
These two you cannot compartmentalize.
Right.
This has to go simultaneously.
Hand in hand.
So the judgment which you are impugning before us, the correct interpretation of the order is that local arrangement court has directed. And if it is not done within 4 weeks, This issuance of a letter that I am calling for names I am not getting, this itself will be in violation of this order. That action is in violation. But you are urging and insisting that you modify the order. With how will we modify? Tell us. Can we say that in making local arrangement, you are not required to find out any teacher? Local arrangement can be made and a decision has to be taken. That decision, suppose a local arrangement is, it is found that from this school he can be brought here. DI shall pass an order. That order may be challenged by that teacher. That is another
aspect, yes.
So these two riders, Mr. Lydie, are inextricably bound. You cannot separate one from the
I'm
other.
not trying to even.
So what modification you are wanting? Tell us.
My lord kindly appreciates.
If you want us to modify, if we reject, we have to give a reason. If we don't reject, we have to give a reason. Can we sit in appeal over the government circular and say that forget about your finding a suitable or not, you transfer him and place any Tom, Dick and Harry in the post? That compulsion the judiciary cannot place.
I'm not even praying before that.
Then what you are praying?
My lord kindly appreciates, apart from these submissions, kindly appreciates one thing. What is the consequence of not finding an alternative teacher at my place? What would be the consequence? First, I'll be the worst sufferer for last 4 years. I'm keeping it aside also. Now, let us come to the statute. When there is a specific reading in this 3rd January notification that in time-bound manner you have to do it, legislature has clearly expressed its mind that you have to do it. You cannot brush aside in the garb of not finding teacher. Now, by not doing so, the 3rd January notification becomes optional. A statute can never be optional.
Then what direction you want? Tell us.
Yes, exactly how Gokul Chandra has passed the direction. Exactly how the Gokul Chandra case has passed the direction. A time limit was fixed that in the between you make the arrangement. That's why I was trying to.
What is the ultimate direction in Gokul Chandra?
What is the ultimate direction?
Yes, with the observation that within 4 weeks you have to make the arrangement. Kindly take paragraph
14.
12 onwards.
14, para 14.
Therefore, direct the concerned dear schools to consider application strictly in terms
Strictly
of the subsequent amendments.
Consider the application for transfer
With the observation.
strictly.
Yes.
So at the district DI of school level,
Yes.
it will come to the commission.
Yes.
Ultimately, commission shall recommend for transfer. Strictly in terms of the rule as well as subsequent amendments having brought by way of a notification within a 4 weeks from date.
After discussing paragraph 6, 10, 11, and 12, that observation is binding upon the DI now. After discussing paragraph 6, 10, 11, and 12, clearly giving the mandate of the 3rd January notification, how it is to be implemented, then that direction comes upon the DI that you act in terms of the observation made in paragraph 6, 10, 11, and 12. Kindly see, that was I was trying to impress upon your lordship by placing these 4 paragraphs. May I just place it?
Which paragraph?
Gokul, 6, 10, 11, 12. Kindly take, I was trying to, have been trying to place this paragraph. Kindly take paragraph 6 of Gokul Chandra Malik. An equilibrium is sought to be made between the rights of an incumbent seeking transfer and the education to be imparted to the children for which the said notification dated 3rd January 2022 was issued, so that the object and purpose entrusted upon the government under the constitution is not violated and or frustrated. It is inconceivable that an application for transfer necessitated by the valid ground shall be kept in abeyance for all time to come until an alternative arrangement is made. Now, my lord, kindly take 10. The said notification cast duty on the DI of schools to make arrangement within the time-bound manner and does not invite any option or choice of any other teacher to volunteer in rendering his service to a school from which the appellant seeks transfer. Though the shelter was sought to be taken under the letter dated 24th of May 2022, just like my letter, that steps have been taken, but the tenet of the letter does not instill any confidence in us that it is in the spirit and tune of the notification dated 3rd January 2022. The moment the statutory provision casts a duty upon the district inspector of schools AC of the concerned district to make an alternative arrangement within a time-bound manner, the way the said authority perceived the said provision having reflected in the said letter dated 24th of May 2022 is against the spirit and soul of the notification dated 3rd January 2022. A stalemate situation is brought in construing the notification dated 3rd January 2022, where the helplessness of the DI of schools is made galore that in the event none of the teachers volunteers to render their service to the school from where the appellant sought its transfer, the transfer application would remain in a cold storage and cannot be brought forward. This cannot be the spirit of the said notification, as the decision of the management of the education system lies with its officials, and the action to be taken within the four corners of the statutory provision, which cannot be whittled down or done away with, perceiving something for which the government never issued such notification. That is exactly my submission was.
সব চেয়ে রেখে নিজে কনসিডার করবে যে কাজ
দেখানো হয়ে গেছে তো কতবার দেখানো হয়ে গেছে
যে স্কুলকে পাঠাচ্ছে যে তুমি কাউকে স্পেয়ার করতে
কিন্তু তুমি ওই রাইটারটা What is the modification you are wanting?
Modification that paragraph 15 of the implement order, that in the event he is found and will be allowed that request to be interfered by your lordships in the event, because it makes optional again. Now, my lord kindly fixes a timeline in between the temporary arrangement is to be made and I may be released. That one simultaneously. I'm not seeking give me priority or precedence. Though it reflects from the Bokul's report, whatever, I'm not seeking that.
Justice Chakraborty says, making of alternative or temporary arrangement is subject to the availability of the teacher.
That is their headache, my lord. I cannot take their headache on my shoulder. I am exercising my right. Law gives me power to come before your lordship and seek my remedy. If they cannot do it, it is their negligence.
Hence, we requested Mr. Dotto, you have to talk with Principal Secretary.
He wants one of the implementation of this notification dated 3rd of January 2020. He has not questioned their challenging. So whatever is there as on date, or the if it is applied or principal, I don't know what is going to happen. But Malad, as on date, Malad, since he has not questioned this, so Malad, the order impugned, perfectly all right. It doesn't require any modification because that will Malad, if that is done, then Malad, this will be Malad, delving into the domain of the administrative authority.
সেই আমি টিচার পেলাম না সেইটাকে এমবোল্ডেন করে দিচ্ছে ইন্ডেক্স
It has creates for all confusions and everything. Now, my lord, subsequent to the order passed in the writ petition, my lord, the DI has taken all steps. My lord, some annexes are there to the affidavit
Steps
of
means steps he has taken, he has only called for information and inform us. This is
now,
not a step.
Lordship kindly sees the annexes to the opposition filed in this matter.
Yes. See what he has said.
Lordship kindly
If available. If available, express your opinion. Why they will give opinion? It is for the DI to take the decision.
Again, letter of consent.
Consent letter.
From your end and the teacher concerned. That is again willingness.
Again, yes, my lord.
Willingness come.
And then on next page 9, Lordship sees in deference to memo understand is unable to arrange for assistant teacher of mathematics from my institution. The school informs page 9 unable to arrange for an assistant teacher of mathematics. The school says, page 91, we are unable to arrange. And then, another school says, page 19, non-availability of assistant
They will never say that I am able to arrange. Which headmaster will say to a teacher that go in another school for local arrangement? Any teacher will give a consent. Nobody will give. So DI has to take the decision.
Lordship kindly sees.
Local arrangement has to culminate in a final decision, Mr. Dotto. We understand that in taking such searching method, ultimately it boils down to the issue as to whether any teacher is found whom I can keep.
Yes.
But this finding has to be DI's own handling, not dependent upon any consent of any headmaster of any school. Going deep into the matter. So
yes,
we requested you.
Lordship kindly sees.
Or you say we will not. You take. You call your. You take responsibility that this we will not take as a precedent. But in this case, there are surplus teachers in the school. All avenues are open so that he can be transferred. Now, DI can sit tight under the guard.
Yeah, Mr. Dotto, in this case and in most of the case, what DIs are doing, he is sending a letter to the headmaster. You inform me whether any such teacher is available or not, or whether any such teacher is willing or not. If answer come in affirmative, then send a letter of consent. Not that. DI himself shall take into account the strength of the student and the position of the teacher in the particular school, in all neighbor schools.
And complete
then DI take decision that I shall send such teacher to that school. It would not be dependent upon the letter or when letter of consent has
pardon to observations.
No, DI shall take information. You inform me the strength of your student and the position of your teacher. Staff pattern, you said.
But the 3rd January.
I shall send teacher Ram to that school.
But the 3rd January notification does not provide for taking any penal action against an unwilling teacher.
No.
Or the school.
But Mr. Dotto, in many districts you have complied with. There are instances where after our judgment,
I'm not posted with that fact, but I'm very candid about it. I'm not posted with that fact, but I'm candid about it. Your Lordship.
অনেক হয়েছে আমারই ক্লায়েন্টদের রয়েছে আমি নাম বলে দিতে পারি অনেক হয়েছে স্যার
এটা তো ওনাকে অপরচুনিটি দিচ্ছি উনি যদি প্রিন্সিপাল
for the information regarding the student strength and the position of the teacher, then DI himself take decision what teacher should be sent to which school. That would be rule, and hence we are not passing this order.
And
hence we are inclined to give you another opportunity to take decision and to have a discussion with the principal secretary. If we pass this order, tomorrow Lahiri and any other
Any,
will come.
any,
That decision would be
DI
prospective.
will
That decision of would
search
be
in
prospective.
that mode and manner.
uh,
That decision of the principal secretary would be prospective. But in my case, as on date, my lord, I mean entitled, my lord.
now, my lord, this one thing, my lord, I just want to point out. 3rd January notification, my lord, the fourth paragraph says, in feet cases, this is very vital. In feet cases, the DISC will take urgent step in time-bound manner to search for a teacher on the same subject from nearby schools and make local arrangement. As Justice Chakravarti was saying that this is a simultaneous arrangement. So, yes, I brought a lot of observation for a teacher on the same subject from nearby schools and make local arrangements so that the teacher of the other school attends the school where from the teacher concerned has applied for transfer on limited days of the week on a temporary basis till such time a permanent teacher on that subject joins. Yes. So this is one of the only this is the real part of the notification 3rd January 2022. Now, my lord, this
In feet is the word.
now the
Feet case.
now the feet cases, my lord, this is something, my lord, it is
ফিট কেসটা আদারওয়াইজ এলিজিবল হলে 5 বছর সার্ভিস হলে কোনো ডিসিপ্লিনারি প্রসিডিং পেন্ডিং না থাকলে তখন
feet cases. I think yes, I think Mr. Lyde is correct. In feet cases, my lord,
But the word feet case has
it
been
is
used.
there in the 3rd January notification. It says yes, in the
fourth paragraph, second sentence.
yes. Feet case means if
Fourth
I'm
paragraph,
otherwise
second
eligible.
sentence. In feet cases,
Yes, if I'm otherwise eligible, if I have completed 5 years of service, there is no disciplinary proceeding in my against me. This makes me fit for transfer.
Where is the word feet?
my lord, the second sentence,
Page
fourth paragraph.
Read.
174.
But if this starts with, in the event that teacher makes application for transfer, the SMC will not reject the application and will inform the DISC about such applications. The DRAC will immediately discuss the matter with the CSE. Then, my lord, in feet cases. Plus, you got it, my
ওটা
lord?
আপনি স্যার টেনেসি পড়ছেন, ওটা টেনেসি, ওটা 9
That is another circular here.
মানে kindly take page 174. 174, it is there, fit case is there. Yes, there. আইনেসি না স্যার টেনেসি পড়ছেন, দেখো তুমি ভালো করে। না স্যার টেনেসি পড়ছেন, তুমি না দেখে কথা বলছো, দেখো স্যার টেনেসি পড়ছেন। না তো নোটিফিকেশন তো ঠিক পড়বে। Page 174 দেখুন স্যার, 174.
174 eligible.
The next page, my lord, there is
174.
Now, why this in the event a single teacher discuss where is this feet case?
In the course, এই সেন্টেন্সটা দেখুন ঠিক হচ্ছে এখানে নিচে
In the event, my lord, that
Page
is
175 is the typed copy.
typed copy.
Where is feet case?
174, your lordship will find the word fit case.
Where?
To make the application for transfer.
I pointed out there are some discrepancies or omission of some certain words. Even a type copy.
this is
Was the circular now? You don't have the circular. Yes, where is that feet?
দেখো না।
lordship.
9 AC তো?
হ্যাঁ 9AC
সারা দিন চলে।
এই তো সেকেন্ড মে আই জাস্ট হ্যান্ড ওভার। হ্যাঁ সেকেন্ড লাইন মাই লর্ড, সেকেন্ড লাইন রাইট হ্যান্ড সাইড ইন ফিট কেসেস।
So in feet, according to you, whether
Second কোথায়?
teacher pair is fit
সেকেন্ড লাইন মাই লর্ড, রাইট
to
হ্যান্ড
be
সাইড,
accepted.
last paragraph right hand side in fit cases. Possible there is some typographical, my lord, it is not there, but it is not legible. It is there. It has also been recorded in Gokul's order also. In Gokul also it has been referred as in fit cases. Fit cases means if I am otherwise eligible for transfer. Suppose, my lord, I work for 1 year. I am
That
fit for
may be
transfer.
Mr. Lyde's interpretation. I don't know what is feet
Yes,
cases.
it has been discussed.
Feet cases may happen in certain circumstances beyond what Mr. Lyde submits. Maybe.
Yes.
Feet cases, whether eligibility is one of the conditions, whether eligibility, whether 5 years have been put in service or not. That is one. Then maybe other, there may be some.
Teacher is found. Further clarification.
My lord, it is nil.
What you are saying is that you make an observation that in the event a teacher is found cannot be a precondition for consideration. If the DI is to search, the ultimate conclusion will be to search and find out whether there is any other teacher through whom this local arrangement can be made. These two issues are inextricably bound. So in that case, there is no question of modification of the
My
order.
lord, may I? Let it be
We are not.
simultaneous. Let it be simultaneous. I'm not seeking precondition. Let it be simultaneous, as it had fallen from my lord Justice Chatterjee that the DI will decide who will go where on temporary basis. Let it be simultaneous. I'm not saying that give me precedence, that send me first, then you arrange. No, let it be simultaneous. For the interest of education, let it be simultaneous. Let the DI take the call as contemplated in third general notification read with Gokul and had fallen from my lord Justice
In
Chatterjee.
that circumstance, and hence we could have passed this order earlier. We asked Mr. Dotto to have a talk with Principal Secretary.
Yes.
In that circumstances, it would be a giving prescription regarding mode and manner how DI will search by this court, although in the circular such mode and manner has not been prescribed.
Mentioned, yes.
Okay, we being a division bench, we are making this prescription.
Yes.
That in this mode and manner DI will search. But circular itself did not prescribe such mode.
Lordship may not possibly go to
And
that intricacy.
hence we are
Because Gokul Chandra
Mr.
Malik's judgment,
to have a talk.
my lord, whatever the discussion with the principal secretary will be prospective in nature. That will not have implication in my case here. Only Gokul Chandra Malik's, the way the observation has been followed and given direction to DI, that would serve the purpose. I've only come for that. That would serve the purpose.
Gokul Chandra, after discussing, has ultimately said, considered in terms of the circular.
Yes, I'm praying that only. But
So this is also consideration in terms of the circular.
it says that the observation is not there. The Gokul's observation is not there.
We cannot repeat the observation in the fact of this case.
So your lordship, facts are similar. So my lord kindly decides, my lord kindly
Go in contempt.
No, my lord kindly appreciates because you just a minute. My lord, kindly give me
We have heard you.
2 minutes. Your lordship has passed an order. Contempt would not lie, my lord, in my case. Your lordship had passed it. Not
2-3
accepted.
paragraphs.
Gokul has been referred but not accepted there.
No.
Gokul has no.
No,
Kindly
judgment is.
And my lord, your lordship has passed order previously also. After that, even it has not been done. Your lordship passed, this bench had passed the order previously. My lord, if they had to do it, they would have done it by now. They would never do it.
We are not, we are unable to appreciate what ultimately Gokul has said. Gokul has said that application should not be kept pending for an indefinite period. Its circular itself says time bound manner.
Yes, that is the interpretation.
Yes.
When the legislature has used the word time bound manner, that means the legislature has expressed its intention that don't keep it pending for indefinite period.
Exactly, Gokul says the same, that you do not keep it in the
Same
bucket.
thing has been stated in Gokul.
Yes, I'm praying for that only.
That cannot be kept pending for
Exactly, that is my
indefinite
submission,
period.
my
Same
prayer.
thing.
Since 2022, it is being kept pending, similar to Gokul.
By virtue of this order, DI যে স্টেপটা নিয়েছে, DI যে স্টেপ নিয়েছে তার থেকে বোঝা যাচ্ছে যে যতক্ষণ না কনসেন্ট পাবে ও কিছু challenging an order dated Yes, এটা you you after we sign the order, you
I
take
don't
back
require
the
anymore.
copies.
No, I don't
We
require.
want that fresh notification copy.
Yes, ওটা কনকদা তোমার কপিটা যখন দিচ্ছেন। না না,
Which one?
টাইপ করে ফেরত দিয়ে দেবে।
Which compilation?
That
Acha, Mr. You give us that fresh copy of 3rd January notification.
Yes, I'm just requesting Mr.
there
Komala
are-
to give me a
এদিকে
copy.
দাও
I'll give
আমায়,
it
আমি দিয়ে
photocopies.
দিচ্ছি।
I'll get
there are two notifications of the same date. One 9E and
9AC
10E.
and 10AC.
We have put it
9AC and
from
10AC.
9AC.
9AC.
So what is 10AC?
10AC is regarding 10%. When the application made is beyond 10%,
Oh, I see.
there is a bar.
So the 9AC is relevant.
9AC. Acha, ওই notification dated 3rd January.
I brought Mr. Banerjee Millet, item number 5.
Your juniors will not bother to attend the Apex.
Millet, I
education
take the
and
responsibility.
people can enter smilingly in the court, and the court proceeding can be interrupted at any time the advocate desires. You are setting up a bad example. Setting up
I'm
a bad
sorry.
example. Since we are being lenient, you are taking advantage of our leniency.
I'm
File an application.
Committed to pension. My lord, my lord.
Event পরে চলবে। Thursday week, ঠিক।
My lord.
Item number 12, I appear for the appellant, led by Mr. Ali Hassan Alamgir.
What was the matter about? What was the matter about?
The matter is about the higher pay scale. That single judge has passed an order in my favor. Actually, my lord, in that matter, during the time, my lord, I was appointed. At that point of time, my results were not published. Subsequently, the results were published and I claim for higher pay scale. My lord, it has been settled by the larger bench. And my lord, there are other judgments also. And there is a specific government order under Control of Expenditure Act 2007. That during the appointment, if my results are not published, subsequently I can claim. It is their appeal, they have filed.
কোন ম্যাটারটা আছে ওটা
Still of
অর্ডারটা ছাপাতে বারণ করে দাও আইটেম হ্যাঁ You people are becoming senior. Don't indulge in yourselves in this.
I'm so sorry, Millet. I understand.
While we were on the bar, matters were dismissed for default. We even could not reach the judge. By that time, matter is dismissed. You also remembered.
I remember, Millet. I remember.
So can this be suggested that
No, my
the
lord,
court
no.
which is
Not at
lenient to the advocates,
Right.
sense about their running in the corridors, do you set a good example?
No,
We
certainly.
will be branded as the judges who will never dismiss matters, whatever comes. Any person can appear at any time. Take it as it should.
I apologize.
You should have scolded your junior on that
I
issue.
have, Millet. I have.
You people are so busy that
No,
you
my lord.
feel that we can dictate matters sitting in our chamber.
No, my lord, certainly not, Millet.
Please don't test the patience of the
My-
division
my-
bench.
my-
Yes. You are our brothers. It is your responsibility. You are our future.
My lord.
And if this attitude continues, no junior will respect
True,
the
Millet.
court.
True. Absolutely true, Millet.
And they are subdued when we become strong. What can you do? If just now I said that you file an application, can you do anything else? And you know the embarrassment that will be caused. We were there with
Exactly,
you.
Millet. Exactly, Millet.
A client to be called and to affirm and restoration
For the
application.
purpose of the restoration and
For
have to
that,
call.
we used
We-
our
exactly.
juniors used to throw us out of the
My-
chamber. for such conduct of ours.
That I have a little experience.
Item number 12. I wish to appear on behalf of the appellant, led by Mr. Ali Hassan Alamgir. On the last occasion, time was given for filing the affidavit in opposition because there was a CAN application under section 5.
Yes.
We had a delay of 160 days. Now, Mr. Dhar was appearing and
Oh, you want to file reply?
yes, my lord,
Reply have been filed.
reply also.
Oh, you have given copies.
One indulgence. I was just praying for a lot today since I was led by Mr. Ali Hassan Alamgir. He is engaged in courtroom number 9 for a matter. Just
What is section 5?
this is the section 5.
How many days delay?
160 days. Now, Mr. Dhar was appearing and requested the court that she wants to prefer an opposition.
9th February দিয়ে দিয়ে take back your affidavits filed on that date.
Grateful. Lord, I am appearing for the state respondents. my lord.
I am for the appellate, but at late petition. My lord, issue is, my lord, single teacher. Time only, I am praying only modification, my lord, time bound manner.
You have rectified. Defects were there.
My lord, section 5 is there,
Section-
my lord.
How many? 249 days delay.
Yes, sir. My lord, why 249 two delay? My lord,
Why you are opposite?
My lord, I am for the state respondents. my lord.
না না delay party তুমি অপোজ করছো
My lord, 249 days in my application, my lord, it is not mentioned.
It is 249 days. What was the main matter?
My lord, main matter is, my lord, single teacher, my lord, honorable single bench directed to follow 3rd January notification. My lord, I am only praying some modifications. My lord, there is no, my lord, I am only praying, let the DI shall exercise that power in a time bound manner. That much I am praying. Since, my lord, they have not exercised that power, that calling the local teacher, local willing teacher from the neighboring school, that I am only praying, only modify to that extent, my lord, let the DI exercise that power in a time-bound manner, in respect, relying the decision of the Rupak Dhua, my lord's order, my lord, honorable single bench is also following that order, my lord, passing several order. So, my lord, only I am that to that extent, my lord, I am playing modification. This is the matter. Nothing more, nothing else.
Willing teacher.
উইলিং টিচার এখানে আবার ফিড টেস্টটা ইয়ে করে দিচ্ছি
Rupak Dhua, my lord, kindly see your lordship's decision is a time-bound manner. Your lordship decided the issue. Lord Rupak Dhua, only to that extent.
বলছেন
Single teacher is there, my lord.
Okay, we are coming into the merit later on. Delay.
Your lord, actually, your lordship.
No, we have passed a ordered modify. Show him this order.
Yes. Rupak Dhua is it. My lord's order is there. My lord,
Subject to correction, my lord, honorable single bench, after passing your lordship's order, honorable single bench is also following this practice, my lord. This is the present order of honorable single bench, my lord, relying the ratio of the Rupam.
Same judge.
My lord, no.
Same
No.
court.
Present, my lord, sitting judge.
Change it. Educational training.
It's the latest situation of the honorable single bench, that ratio of Rupam is.
Okay, delay condone. Since you are leaving this matter to our
Yes,
the present appeal has been preferred. Next.
Oh, not today. My lord, I am led by Mr. Fidosh Shamim. He is not in the court because he has his father is suffering from a medical emergency and he have to leave town. So, my lord, can you grant or not today?
9th February.
It's a bit urgency because arising out of second SLST, today I am not opposing.
What is can 1?
Can 1 is leave to prefer an appeal because I was not added as a party respondent in the writ petition. The order which has been passed in the writ petition has affected me. Because of the order passed in the writ petition, my candidature in the second SLST has been cancelled. So therefore, I'm aggrieved.
Will come tomorrow.
Yes,
then?
yes. I will not object.
Yes, next.
Matters cannot.
Grateful, my lord.
Tomorrow he will be available.
Yes, yes, my lord. Babar ko sorry.
These things cannot be opposed.
Next week. 3rd February then. 3rd February.
Come 3rd February.
Grateful, my lord.
At 15 minute, I'm for the writ petitioner respondent.
Delay. How many days?
Lord, 293.
You're opposing?
And I'm opposing.
File you're opposing?
But 250, I'm not opposing.
Delay you are not.
I'm not opposing.
253 days delay, my lord, filing my affidavit of service.
You are for which respondent?
Read petition.
You are for
The
which
writ petitioner respondent, man.
Follow
Writ
the
petitioner
code.
respondent.
Oh,
The work which you are doing ought to have been finished outside the court. Don't stand in front of the court and clean your specs. Yes, what is the matter about?
Malot, impugn order is at the Malot in the memo that has been annexed. May I Malot briefly? Malot, writ petitioner respondent Malot has filed a writ petition in the year Malot 1978 with the Malot the
Order impugned is 11th of
yes, 1978, 11th of
March.
Yes. Malot 11th of May 1970 is the impugn order. Is the impugn memo that he has said.
Which order are you?
Malot, I am challenging 11th of March 2025. That is the final order. Now, in the writ petition, the impugn memo is 11th of May 1978. Malot, by that impugn memo, the Malot, the respondent, Malot had Malot restored the service of the previous headmaster in the school, and Malot, and because of that particular restoration, the petitioner, as per petitioner Malot allegation that his service as a headmaster at that point of time was automatically Malot gone. This is the particular memo that he had challenged in the writ petition. His Malot case was a case that he had made out in the writ petition that I was a headmaster by virtue of a advertisement issued by the school, and I accordingly Malot appointed, and my appointment was Malot approved by the DI of school. But subsequently, when I was discharging duty, the erstwhile incumbent of that particular post, by virtue of this memo, was restored in the service, and because of that, Malot, my appointment as a headmaster had gone. This is the
gone
case.
In which year?
Malot, sorry, Malot.
Headmaster post gone in which year?
Malot, 1978 by virtue, because the previous incumbent of the post.
We understand,
Yes,
but from when he was discontinued?
Malot discontinued his contention that he, even after that memo, he continued up to 1985. Thereafter, Malot, he had not been allowed to discharge his function.
So his entry was in which year?
Malot, that is 1976 as a headmaster.
76 to 85.
85, as per his contention.
From 20th December 1976 to.
So the deficiency in 10 years.
There are Malot with this particular writ petition. Petitioner has Malot filed the writ petition, and that writ petition Malot has been kept pending.
No, when was the writ petition filed?
Malot, it was 1978 itself.
Yes.
Now, what happened?
Now, up to 85, he continued.
He continued.
Before that, he has preferred the writ petition.
Preferred the writ petition.
Now, when did that incumbent join the post?
Malot, that incumbent was Malot in the post prior to 1976. Prior to 1976. And it was also a case that was made out in the writ petition that that incumbent had Malot resigned from the service, and that resignation was accepted by the then managing committee. But what happened? The impugn memo, by the impugn memo issued by the board, Malot, wherein Malot another
but
order
ultimately has been directed by the court.
The court had directed that the person in due course had retired from the service. The court had directed to amend the prayer, and considering that particular Malot prayer and the content of the writ petition, the court had directed to give him back wages since 1985, to give him retirement benefits. Malot, 1985 to till his retirement, Malot, this period should be spent on duty. He is also entitled for all the arrears salary, including interest. He is entitled for Malot pensionary benefit, GPF, gratuity, and pension. This is the Malot
sum and substance of the direction that was passed in the impugn order.
Have you started provisional pension?
Maloto,
Nothing.
there are Maloto, there are because there is a contempt pending, and we are Malota filing the whatever steps we have taken. Period was Malota, that period was accorded as spent on duty. That much has been done, and we are Malota in the contempt. We are filing Malot because some documents we required.
That has been accepted as spent on duty.
Spent on duty. There is a, I should
That
be
has been
candid, and I have annexed the thing to the.
Very good. Then how can you challenge the arrears now?
Now Malota, Malot subject to correction, Malota, because we are in
Where is that memo spent on duty?
Malot, that is by the board. The appellant here is the DI of school, the pension sanctioning authority. I am showing Malot. Kindly come to Malot, page 95 of the application for stay. Page 95.
This was issued on
30th of April 2025, and thereafter Malot.
Then why you are not giving provisional pension? Disburse admissible pension, and in the event for any reason whatsoever pension cannot be disbursed, the petitioner shall have to be paid provisional pension. That also you are not complying.
Malota,
Not a single penny has been paid.
What I am on, Malota, because
May I place it, my lord?
The person Malot since 1985, Malot did not attend the school.
It is a contested order, Mr. Prasad.
Malota, that is what is there. I cannot improve over it. But the issue is, Malota, as your lordship, Malota, subject to correction, Malota, a person who is Malota, Malota, for a long period of time, Malota is not attending the school. Malot, there is a provision of deemed Malot resignation in the leave rule itself. And another issue, Malot, that I want to point out, Malot, a person who had not worked for a longer period of time, and at that point of time he was earning. Malot, I should be candid, Malot.
Did you file any opposition to the report?
Malot, only report was called for, a short report that
Where
has.
is that report? Have you annexed?
Yes.
Everything was admitted in the report.
Report, Malot, page 47 onwards.
Yes, there.
Make that page.
47 onwards. And kindly consider another issue, Malot.
The report is at page 51.
This is the report filed by the board.
From
and
47, it is the affidavit, and 51 is the report. Man. Everything was admitted. Man.
Then why you are not opposing the section 5?
My lord, section 5.
My lord, throughout our career, my lord, we do not oppose section 5 because it has been, my lord, in the Supreme Court, my lord, I was
doing owner matter, my lord, that it fell from the Lord Chief Justice. When there is a merit, a delay will not create any problem. Even if 16 years delay, 6 years delay, judgment is there. So, my lord, we love the profession. This is our temple. We will come and go. So, no section 5. We will never allow. Even if there is no merit, section 5 is a bogus petition, baseless petition. We do not oppose. Kindly come, my lord, dispose on merit.
Other aspect is that when now the person is of 84 years, 85 years old.
And my lord,
I
his
think
wife is
since
suffering from cancer, my lord.
Both cannot suffer. Either you argue that or let him argue.
My lord, his wife is suffering from cancer. So that's why, my lord, we do not want to make it a lengthy one. We do not want to oppose to section 5. Whatever in merit, your lordship kindly decide.
Ashok, in connection with the present appeal and application being has been preferred.
Malota, as Malota has given a very within by that period, Malota, the entire matter will be finally decided. I am only seeking Malota for the timing. Let it be Malota. This matter should let it be. We should wait for the Malota result of the retreat.
My lord, they are taking a double stand, my lord. In the contempt proceedings, my lord, they are saying.
The appeal is pending.
But in the contempt proceedings, they are saying that only because the school has not sent the file, we are not able to prepare all the service book and other things, my lord. In the contempt proceedings, and again here they are preferring appeal against that order, my lord.
My lord, in the
That is the entire scenario, my lord. And what has happened, my lord?
contempt, my lord,
School said that we
When
are
a
not in a
retired
position.
employee against whom a case under section 302 is pending is entitled to get provisional pension.
yes, my lord has already decided.
And my lord, I am not terminated, I am not suspended, my lord. I am thrown out from my service. All of a sudden, he came and just by a memo, he thrown me out.
My lord,
When my appointment was given
one
by
thing I
pursuant to
should
the
point out
advertisement,
before your lordship.
PI has approved my appointment.
My lord, one thing I should point out, my lord.
Don't point out now. Come on, 30th
Yes.
and point.
Or let it be for the
Get
time being, my
yourself
lord. I am
ready.
only seeking, my lord,
No, my lord.
first stay.
No, my lord, I am opposing.
No stay.
No.
Yes.
30th, my lord.
Incorrigible attitude. DI sits in his chamber and after 20 years, who will give the money? It will go from the public exchequer. Huh? And if we first realize it from DI, you will next day come up with a clarification. My DI is innocent.
My lord, I am.
Amend your ways, Mr. Prasad. High time. Government should be active now. Amend your ways.
Yes, yes.
LR
approved.
My only point before your lordship to decide is that
judgment
I was an advocate at that point of time.
Okay, come on.
My lord, 30th, man. I'm
Today
grateful.
we have two matters.
My lord, I'm grateful.
কি আছে দেখো তো এই ফাইলটা একটু পাঠিয়ে দিন আছে
বুঝতেই পারিনি
nobody for the nobody for the writ petitioner.
Mr. Bari is appealing.
তুমি ওটা বলে দাও
The application for condonation of delay is allowed. Delay in preparing the appeal is condoned. The appeal admitted. Okay. Necessary order shall.
The main matter, my lord, will appear.
Madam, may be fixed.
Next,
Release the matter for further consideration. On 5th. No. 5th.
Under the same heading করে দিও
Under the same heading.
Fixed on 5th February.
5th February.
Number 9. Okay, delivery.
Okay. Yeah. Matter is still going on. Another matter is going on.
কি বোঝাবে তুই?
May I be permitted?
Yes, but you are permitted. Who is your senior?
My Lord, advocate on record for the petitioner is has gone for SIR hearing in his village. So I just only praying for.
You also.
My Lord, I just got.
I appear for the respondent.
একে কি বলতে হয়, কি করতে বলেছ? কি করেছিল আপনাকে? 7 nominating. পালায় কত তাড়াতাড়ি ফুটে পালায় যায়। এমনিতে সঙ্গে যা হোক করে একটা ফিরতে পারবে। We have discussed the your writ petition was
My writ petition, his writ
their
petition,
writ petition
that was allowed. And my lord, we challenged the same before this appeal court,
Right.
and we have been enjoying a stay.
No, because he is stalling the content.
In the
This appeal.
appeal,
In this
there was, yes, there was a
So
stay.
I will be praying before your lordship.
We have decided the appeal. We have dismissed the
Kindly
appeal.
reject my prayer.
Go to Supreme Court.
Kindly reject my prayer. That my prayer for
My lord,
stay.
kindly direct them to allow me to join.
After delivery of judgment, Mr. Jahan, learned advocate,
Passed over malata.
Chalo. It has come back.
On the other side.
Huh?
Number 9.
You are the other
Oh.
side.
Oh.
My lord, I have informed other side, but
On the other side.
We are let it be in the list. We are recalling that order. Dismiss for default it was. তো ওটা অর্ডার পাস করো না টুডে করবে
tomorrow, my lord. He'll do the matter tomorrow.
Huh?
You appeared in the morning.
It will remain in the
Take it
list.
first.
তাহলে who appeared?
Few appears.
You appeared.
None appears on either of the parties. On behalf of either.
তাই কি ফ্রেশ অর্ডার
হ্যাঁ
কালকে দেখে নট টুডে করে রাখো অর্ডারটা রিকল করে দিন অর্ডার লিখে আর আরেকটা যেটা হয়েছিল সেটাও তো ওটা
Item number 4.
who is your other side?
But School Service Commission is the answering respondent.
Ask them to come. Morning they were there.
No, when the matter was called on,
Nobody was there.
Item number 16.
I appear for the appellant. I am led by Mr. Shomu Mojumdar in this matter. My lord, there is a delay of 66 days.
66.
My lord, this is my affidavit of service. Can 1 is, my lord, the Section 5 application.
Or is there affidavit of service?
My lord, I have filed my affidavit of service. My lord, state is the answering respondents here. I have served upon Union of India, UGC, and state respondents as well.
Are you appearing for the state?
Yes, my lord, led by Mr. Joyanta Samantu. He is coming, my lord.
Where is the order impugned?
My lord, the order impugned is at page 332 of the stay application.
How many days delay?
My lord, 66 days.
66.
Lordship. Can 1 is the Section 5 application, right?
69 days. 69 days.
My lord, I have the prayer portion, I have made it 66, my lord, after assessment.
Okay,
which page did you tell us? Page?
My lord, 332 of the stay application. My lord, the
332.
impugned order. Lordship.
Oh. 16 September 25 order.
Lordship. My lord, the writ petition was dismissed on the ground that adopting UGC scheme and giving implementing date is a policy decision. 332. My lord, it starts till 344.
Writ petition dismissed.
Lordship.
So there is no scope for any interim order.
My lord, I was only beseeching if your lordship kindly condones the delay and fixes a date. My lord, I have annexed all the, my lord, pleadings in the application itself. My
File
lord,
a paper book. We are giving you time. File a paper book incorporating all pleadings.
my lord, everything is here.
Why it is better to give a paper book to handle the documents. And you are how many petitioners?
My lord, I have paid all the, my lord, stamp fees, my lord. Petitioners are, my lord, 50
It will be
petitioners.
convenient if you file a paper. There are more than 50 petitioners.
Yes, my lord, 50 petitioners and 2 pro forma respondents.
What was your challenge in the writ?
My lord, in the writ petition, we have challenged one government order dated 30th of December 2019, whereby, my lord, pay scales were revised for the university and college teachers. My lord, the appellants herein are the assistant professors, associate professors, and professors in different state-aided colleges, which
So
was
you are challenging the revision which was effected.
lordship.
So that was not to your benefit.
No, my lord. My lord, we have been
your pay was stepped down.
Lordship, my lord, the issue was with regard to the implementation date. My lord, we were not given the effect from the, my lord, the date in which
1st January 2016.
Lordship.
Which date, from which it was given effect to?
My lord kindly considers the notification. My lord,
It was given from 1st January 2016.
Lordship. My lord, we have been brought under the purview of ROPA, my lord, which is, my lord, not in this case. And in lordship, the process
Of 1st January 2020.
Lordship.
In your case.
Lordship. My lord kindly considers the notification, which is at page 158. My lord, which was under challenging the writ petition.
Why did you challenge, madam? It was you challenged government order of 30th December 2019, where the pay scales were revised in terms of 25th September 2019.
My lord, the petitioners have been receiving, my lord, paid the revisions which has been implemented by state government for teachers of state government colleges, aided colleges, without any deviation from dates of effectiveness, which has been mentioned by UGC. My lord,
The short question is not whether the UGC prescribed pay scales would be applicable to the teachers of the state-aided universities or the colleges.
It is prejudicial to you. Why the date of effect?
One is date of effect.
You want it from which date?
The date on which not the UGC prescribed the pay scales
That
for
is
the purpose of
16.
16. Number
But
one.
they have given it to you from 20.
Number one. Number two.
Are they making any recovery?
No. They have implemented it from 2020. So the effect of pay revision is not for 10 years.
No, they implemented with effect from 16.
Notional increment. Notional implementation from
then
actual
what?
From 20.
But you are saying it should be from actual
16.
benefit from 16.
Number one. And number two, whether the teachers, they are amenable to state ROPA.
But you accepted the 2020 fixation.
That was under challenge.
You say that ought not to have been made.
That not to have been made from 2020. It should
Very
have
good. But you accepted the revision after 2020.
This time they have in toto engrafted it in the ROPA 2020. Without any deviation from the UGC framed pay scales.
So it will be hard.
Yes, no, there is no scope of an interim order.
Ashok.
But this time it is from 2020. Next time there may be a different pay scale.
Mr. Mojumdar, file a paper book. We are finding it.
But all documents are there.
Please, opposition.
I can আপনার ছোট গান
Heavy
Item number 17.
My lord, I am for the applicant in this matter, my lord.
Restoration
Yes, my lord.
filed within time.
Yes, my lord. My lord, I have filed. It is the order was passed on 12th December, and I have filed within 9th January, my lord.
You have served.
Yes, my lord. They have appeared, my lord.
Should I leave it to lord?
This is it is application stage or appeal?
My lord,
Paperwork
paperwork has been filed, my lord. It was fixed for the hearing. Due to the non-appearance of the applicant, my lord, matter was dismissed for default as no one was appeared, my lord.
March combined list the other.
Can two of
Item number 18.
In item number 18, I am for the appellant. I am paying 1 week time. They have filed an opposition. We should have to file reply there too. That's why 1 week time can leave.
এগুলো সব মেনশন করে আসা না? You have already prayed once for extension. How many time we will give this?
Last time can you give in below?
2 weeks.
2 weeks, month for it.
এইটা না এরকম করো।
Much for it.
Item number 19.
The
19 my lord, we are for the state respondent. Section 5 is there. Section 5 is there. We have filed an opposition, my lord. Reply has not been given to us.
delay of how many days?
312.
you have served opposition yourself.
Yes.
No one appears on behalf of the appellant.
Item number 20. The 20, I'm appearing for the appellant. Read petition.
Mr. Bosu Mullik is no longer there in the panel.
Lord, yes, last occasion he appeared, Lord.
Appeared?
He appeared, Lord. And
Where
wait for
is
some
your
time.
supplementary evidence?
Lord, I have filed it him on the last occasion, Lord. And the copy has been sub. And after perusing that, Lord, your Lordship has been pleased to direct him to take some instruction. Lord. So far I could remember, that is also depicted in the order, Lord. My case is that, my lord,
Yes, the upgradation was without financial benefit.
Lord, I believe, my lord, with regard to that, my humble submission is that, my lord, since in a vacant post, I was appointed as a headmaster, recommended by the SSC. So this, with regard to this should not be applicable to my case. It is my humble submission, because your lordship kindly.
What will not be applicable?
My lord, if your lordship kindly come to page 17, my lord. This is my page 17 of my stay.
17.
Yes, your lordship. This is my recommendation.
As headmaster?
Yes, your lordship.
What is the date? 14 January 2006.
Yes, your lordship. 2006. Lord.
Now, what is this?
In respect of a regular vacancy, I was appointed, and I was.
Where is your date of approval? Approval memo?
Approval memo on the next page, your lordship.
So your date of approval is 22nd of February 2006. Then what happened?
Thereafter,
this was in
the
a
case was
headmaster in a class 8 school.
Class 8.
Class.
Junior high school. Lord,
Where do we get it?
Lord, if your lordship kindly sees approval, letter of approval, Lord, at page 18. At page 18, Lord.
So you are the headmaster of a junior high school. Very good. Now,
now, Lord, in the meantime, during my appointment, there was a case was pending with regard to upgradation, because school was wanted to be upgraded, but it was not done. They approached the Honorable High Court. In the meantime, in the High Court, the order was passed and directed to be upgraded. In terms of that order went to the contempt, and thereafter they upgraded the school. This is your lordship can now, Lord.
Very good. Now, what is your grievance?
My grievance is that, Lord, since the school was upgraded
with effect from
your lordship kindly sees the in terms of your lordship order, I have annexed the upgradation letter in the supplementary affidavit. Lord. It is at page 9 of my supplementary affidavit. On 22nd of January 2007, the school was upgraded.
It was upgraded from 29th December 2006. And your appointment as headmaster in junior high school was prior there.
So, Lord, in respect of regular
It was on 22nd February 2006. Yes, very good. Then what happened?
Thereafter, my lord, I subsequently some persons, three teachers of that school, along with a non-teaching staff, approached the Honorable High Court for upgradation of their pay in this since the school was upgraded.
No, headmaster, you cannot be automatic.
No, not automatic, my lord. I know there is a your lordship is saying for the Control and Expenditure Act. Your lordship.
No, for you have to participate again for being selected as headmaster of high school. There cannot be automatic
But
pay
my lord, your
revision.
lordship kindly appreciate, my lord. Since the date of
No, our appreciation won't help. This is
Yes.
the judgment delivered.
But my lord,
Beforehand, it was that teacher litigation came up working as teacher in charge of junior high school. He wanted to be appointed as headmaster after upgradation. That was not allowed.
but my lord, if your lordship kindly sees, my lord,
I have teaching experience in secondary school.
Secondary
But
school.
my lord, I have the requisite qualification in respect of that post, my lord. If your lordship kindly sees, if your lordship kindly sees my qualification which has been mentioned
What
in
is
my
where is the bring the school service commission rule? What is the rule for appointment of headmaster in high school and for headmaster in junior high school?
My lord, the requisite qualification in respect of a headmaster of a high school, it is my lord postgraduate. So, my lord, on the date of my appointment,
No, there is an experience issue.
my lord,
There has to be a fresh selection.
5 years teaching experience. Hospital.
82 সালে prior to commission act. এটা কমিশনের সার্কুলার রুল আছে তো।
There is a rule. With regard to that, my lord, I have submitted another 3 rules with regard to the upgradation.
Where is your writ petition?
Writ petition. Your lordship kindly take pain to that. Come to that, my lord. Take
Where
pain
is
to
your writ petition? Let us see the prayer. What is your writ petition prayer?
Petition to the historian.
The writ petition has not been done.
New style.
Prayer was for the upgradation of my service, my lord, as a head teacher of the high school, my lord. Because on the same school, my lord, they approached this honorable high court, and their on the same point, their prayer was rejected, and after approaching this honorable high court, this honorable high court has set aside those grounds, and state has accepted that order, and till date they are paying.
You were not a party to that.
No, my lord. I have approached subsequently. This is
you satisfy us that you are eligible for headmaster of a junior high school.
Your lordship kindly sees the I have already given on the last occasion the circulars with
Which
regard to that
circular? Circular of 82.
82. Yes.
Sir, you know there is a School Service Commission Act. We want to know the qualification of a headmaster of a high school.
This is I so far subject to lordship question, my lord. So far the same is, my lord, it's a postgraduate degree in respect of high school, my lord.
Do you have it or not with
No,
you?
I don't have the School Service Commission Act with now.
এই আমাদের আছে এটি পাওয়া যাবে আমাদের ভালো করে
postgraduate degree হবে।
যেই গ্রাউন্ডে রিজেক্ট করেছে সেই গ্রাউন্ডটা হবে, অন্যান্যদের দিয়ে দিয়েছে ইন কমপ্লায়েন্স অফ হাইকোর্ট। যদিও
টিচিং স্টাফ নন টিচিং স্টাফ 9-10টা হলো উইদাউট ফিনান্সিয়াল
না, তাহলেও মামলা করে দিয়ে দিল। এই যে অন্যান্য স্টাফেদের দিয়ে দিয়েছে ইন কমপ্লায়েন্স। এই এখন পোস্ট ফ্যাক্টো স্যাংশন চাইছে ফ্রম দি ডেট অফ upgradation. You are not eligible to be considered as a headmaster.
Lord,
You were not a party in the earlier round of litigation.
I did not approach. Lord, I cannot
The
include.
headmaster manual এরকম মোটা বই আছে, দাও না।
এইটা মানে আমার এইটা তো আমার request।
দেখতে হবে এটা।
এরকম করে।
Was your prayer rejected by any order?
Yes, Your Lordship.
Where is that? Page? Page?
At page, Your Lordship, 42
Page
of my stay application. 42 of my stay application.
42. Dur Baba. That is the reach petition.
No, not stay.
Yes, yes, sorry.
42. Your Lordship.
Yes. I passed an order.
No, my Lord, that was a mistake by their part, my Lord. It was a mistake. They have stated that
2016 rules.
instead of Justice Robi Kishan Kapoor's name, my Lord, they have quoted here Your Lordship's name, my Lord. I was also surprised by seeing that, my Lord. The entire order was not. There is no reason at all, my Lord. They have only quoted that part.
Now, where is the order passed in other cases?
His Lordship. Is at page, my Lord. It starts from page 43, Your Lordship.
Where is the DI order of 18th March 2008?
You know, that was in their case, that is the date, you know, and the point, Your Lordship, which in that application, that rejection taken by the DI, the same as it is in my case also. And that was rejected by the Honorable High Court, this Honorable. Your Lordship, can you take me to come page 44 once?
44.
44.
Yes.
The grounds which have been taken at this rejection order, my Lord, same as it is of my.
Where is page 41?
Page 44, Your Lordship.
Yes.
Yes, Lordship. Then firstly, secondly,
You satisfy us, you have the qualification to work as a headmaster of a high school.
Lord, I all along had the qualification by postgraduate.
Without going through the book, you will make this submission.
No,
Court
no.
is asking a question.
Yes,
You
Lordship.
don't want to answer that.
No, Lord, I want to
Huh?
answer. I bow down to that.
So
Lord, I
you
want
must
to answer.
learn. Then you must learn that when the court is putting a question, if I am not ready, I will say take time. But don't take us in a roundabout manner.
No, Lord. If you Lordship.
Junior high school. For how many years you are working as a headmaster of junior high school?
Junior high school. I have been recommended on 2006, Lord. 2006. 6 February, Lord, and I have returned in 2016.
2006.
In the meantime, in 2007, the school was updated, and till the date of my return, I worked as a head teacher of that high school, Lord.
You accepted pension.
Lord, I know when I retired. Lord,
when did you file the writ petition?
2016, Lord. First round of litigation, Lord, I filed 2016.
Yes.
That was direct to be considered. Thereafter, this rejection order came. I challenged this order.
Rejection was that no financial assistance.
That is the only.
But the other 3 persons have been given that.
And they have.
So on that ground, you want to get the similar treatment.
Similar.
Though you have retired in 2016. Wait.
10 years on the date of application, even junior high school.
State qualification, junior or high school.
No, qualification to master degree with at least 45%. The 10 years continuous teaching experience on the last date of submission of application in active service in junior high school also. But 10 years, 16 সালে 7 সাল থেকে কি করে পাবে তাহলে?
Others, হেডমাস্টারের একটা রুল আছে কমিশন।
এইটাই।
পরের রুল
দিচ্ছে না
রিসেন্ট সেপ্টেম্বর কি রুলটা কি দেখি নামটা তো না, সেটা তো অ্যাক্টের আন্ডারে।
টিচার্স রুলস এই যে 2015
সিলেকশন অফ হেডমাস্টার রুল আছে।
আচ্ছা, এইবার হচ্ছে এখানে কোয়ালিফিকেশনটা দিচ্ছে
হেডমাস্টারের দিয়েছে
শিডিউলে। হ্যাঁ, এই যে
কেন
এই যে হেডমাস্টার হাই স্কুল আর হাই সেকেন্ডারি স্কুল।
মার্কস অ্যাপয়েন্টমেন্ট হয়নি তো কি পোস্ট অফ হেডমাস্টার অ্যাপয়েন্টমেন্ট হচ্ছে জুনিয়র।
এইখানে যদি এই যে জুনিয়র হাই স্কুল কোথায় দিয়েছে
10 years continued on the last date of submission applicable in a
জুনিয়র হাই স্কুল, তাহলে 10 ইয়ার্স হচ্ছে 16তে, এলিজিবল হবে 16তে, তখন আবার ম্যাক্সিমাম এজ 55 ক্রস করে যাবে। 6
যদি পয়েন্টটা নেগেটেড হয়েছে in a writ petition filed by the petitioner. Syndrome.
in high school.
আমি পাবো না। Financial assistance নেই আমি দেবো না, এই পয়েন্টটা থাকবে।
কোয়ালিফিকেশন এখানে কেন খুঁজছিস?
এখন আটকাতে গেলে তুমি আটকাতে হবে ফ্রম কোয়ালিফিকেশন। When did you retire?
India 2016
Date?
Date is July 31st of July 2016.
Not have rejected.
On this ground, আমরা তো আধার কাউন্টও দেখতে পারি।
দিয়ে দিই বলো, প্রসাদকে দিয়ে দিই, দেখে আসো।
My representation on 15th of July 2016. Before the retirement. Managing college committee also recommended my case.
Give the copy of the stay application. Do you have an extra copy?
Lord, I don't have only one copy.
You give it to Mr. Prasad. He will appear. Nobody is appearing.
But I will copy it.
Can you give it?
No, I copy it and
memo of appeal, stay, and that supplemented you.
I'll certainly.
Heard, Mr.
Also matter, my lord, today, my lord, I have been told me by Mr. Toll that he has not brought the original opposition with regard to the section.
My lord, there is a mistake in the, my lord, numbers, my lord, two numbers, my lord. Another brief has.
Which was that item?
Item number 90.
19 তাই বল
19 19 তাহলে নেক্সট
this week.
নট দিস উইক করে দেবে তার পরেরটা
My lord, my lord, 21 and 22, my lord, my learn on instruction, my lord, my learned senior Jagadish Haldar for the appellate, my lord. He's suffering from high fever. I am praying for not this week.
3 weeks since 21-20.
Item number 23.
Number 23 is the restoration application lordship matter. It pertains to hearing matter. 1st December, your lordship, due to my for lordship matter has been dismissed for default, and within 15 days I have filed the restoration application lordship. Can you restore and lordship can you fix a date for hearing? That's okay.
Right. 3 p.m. fixed matter. Item number 26.
Yes.
Number 32.
Yes, what is the matter?
The lordships may be pleased to recall. Lordships heard this matter. It is regarding that enhancement from 45% to 50% as master's degree for the post of headmaster and headmistress in the recruitment process. Last occasion.
Yes, please.
Yes. Well, the case I tried to make out before your lordships is that
where is the order?
Impugned order? Yes. Impugned order is at our note. Impugned order is at, my lord, page number 332 of the volume 2. Dated 20th of June 2022. There was an interim order passed earlier by the Honorable Division Bench also.
Who are opposing you?
Dr. Patro and Mr. Abhishek Prasad.
Everybody was jumping for fixing up the matter.
So this was usually Lordship fixed after hearing me. Lordship fixed this matter today. Mr. Prasad was standing outside. I found. I দেখেছি একটু আগে। Mr. Dhol is also there.
My lord, we are led by the learned advocate general.
Appear
Why virus is involved?
Yes, my lord. That portion of the, my lord, rules which has been, my lord, amended, that has been, my lord, challenged, under challenge.
Yes, may I just give a nutshell, my lord? That was challenged. Interim orders were passed by allowing the candidates to participate in the recruitment process. Then, my lord, finally, the matter was taken up by the Honorable Single Bench. Initially, my lord, what happened, my lord, 45% was the requirement as per the rules. Now, after publication of the recruitment rules, that 45% at the master's level will be the eligibility criteria to participate in the recruitment process for the headmaster headmistress, first SLST 2016. Now, after publication of the rules, amendment was brought into effect by which 45% has been enhanced to 50%, by dint of which these candidates, they fall below the 50% marks at master's degree level. So they went out of zone of consideration. So, my lord, they came before the Honorable Single Bench, and my lord, interim order was passed that let these candidates appear in the recruitment process, and the subject to result of the proceeded petition, my lord, was ordered. They participated in the process, my lord. Meanwhile, my lord, the writ petition was dismissed. After prolonged hearing, my lord, the writ petition was dismissed, approving that this enhancement from 45 to 50% is just and proper. Now, that was assailed before the Honorable Division Bench. Honorable Division Bench initially passed an interim order keeping 16 posts vacant and not to be filled up of the post of headmaster and headmistress, and directed for exchange of paper, filing of paper books. Paper books have been filed, and your lordship on the last occasion heard this matter. And my lord, contention was that for schools through which headmasters are appointed at under Public Service Commission, as well as for madrasas, my lord, under the Madrasa Service Commission, everywhere the requirement is 45% or 40%. Only in case of School Service Commission for the post of headmaster, headmistress.
So did you, apart from the criteria of 50%, did you come within the zone in the competitive process?
According
you participated?
Yes. Now there is a dispute arose here. Our ranks kept on missing in the list. In the empanel list of empanel candidates, our certain ranks were not given. Suppose my lord, rank 500, then 502, 501 was not there. So that was deliberated.
You want to ascertain whether you emerge to be successful with your 45%.
According to commission's report, only 2 candidates qualified, but we said, we made out a case which they did not deal with, that the ranks which were missing, and in the record it showed that subject to result of the litigation, we say that we qualified. Unless we qualify, you cannot keep those rank missing in the empanel list. So we said, no, we have qualified, but that is why you have not given those ranks. You have kept those rank missing. I mean, I won't say missing. Apparently, it is missing from the list. You have kept those rank separated since we qualified. This is our stand. I would establish with the documents also that we established on the last occasion also, my lord, on this point. Moreover, my lord, there is NCT regulation. NCT regulation clearly specifies that 50% or
you people are not ready. Matters are fixed. Advocate General, is this an excuse? Is this an excuse, Mr. Dhol? You are quite senior now.
But
take responsibility. All matters Advocate General will come, not
she
come.
wanted to directed me to hand over the written notes of argument also. I have prepared that also. And before the Honorable Single Bench,
you give the rules and the amendment and the NCT regulation.
It's all annexed in the paper. It's all annexed in the paper.
So we tell the page.
Yes, my lord.
Rules.
Rules. Yes, my lord. Kindly come to page 43 of volume 1.
43 of
starting from page 43, volume 1. And before the Honorable Single Bench, Learned Advocate General did not appear in this matter, possibly subject to correction. Yes. Page 43, my lord, is the rule. Starting from page 43, relevant portion at page 49.
Rule make in exercise of power, section 17.
Yes,
Yeah.
they have the power to amend. Page 43.
So power to amend is
They have,
available.
they have. I'm not doubting.
Available to him.
Yes, yes, I'm not doubting that.
We
I'm
are
not
finding out the same.
No, I am not disputing
So where the power to amend was reserved, take us to that
that. It is under section 106 of the Act.
10?
Of the School Service Commission Act. The power conferred section subsection 1 17.
17 is the rule making power
Power
has been given.
is subject to correction, my lord. It is in section 106 of the SSC Act. Yeah. It will issue headmaster's manual and issue. The relevant portion is at page 49. Page 49.
49 is the prescription, what will be the qualification.
Yes, yes.
But the power to amend such qualification is available to the state government.
It is available. I'm not disputing.
Ah.
I'm not
Now other amendment.
Yes.
Take us to the amendment.
Amendment. Your Lordship has already seen that 45% is required. Your Lordship has seen page 49. Page 49, my lord.
Yes. 45.
Very well.
Yes. Now you take that amendment.
Yes, my lord. Amendment at page 54.
54.
54 is the amendment, my lord. Starting from 54, kindly take the first page itself. Yes.
So when did the selection commence? When was the advertisement?
16. Advertisement, my lord. Within 16.
Prior to amendment. Prior to amendment, advertisement?
No, after.
Amendment was on 23rd March 2017.
Yes. I mean, notification on 12th June 2017.
June.
Page 50.
After amendment.
After amendment.
Where is the advertisement?
Page 58. Page 58 is the advertisement.
How many petitioners are there?
In total, my lord, in this paper book there is 1. In next total 16.
Same matter.
Same matter.
All were heard analogously.
Last occasion all were hard analogous.
By the
Read
learned.
court.
By the learned single bench.
Yes.
Now, where do you have annexed the reach court order?
Yes. Page number 332 of volume 2. The order.
See?
32. Dated 10th of June 2022. Starting from 334.
Entire judgment আমার একটা না। বলা মুশকিল। System.
This is for headmaster high school.
High school. 9, 10, 11, 12.
So all the petitioners are serving headmasters in junior high.
Assistant teachers, after having 10 years of service, they are eligible to participate in the recruitment process of headmasters. So they, as assistant teachers,
Yeah,
they
otherwise
participate in the recruitment process. But in-service headmasters were also allowed to participate. I raised this point. For in-service headmasters, this requirement of 50% was not made available. But for them, in the same recruitment process, it has been made available to them.
So you are not for those serving
No,
as
no, no.
headmasters. You are fresh, you are assistant teachers.
I'm assistant teacher.
ইন সার্ভিসের ক্ষেত্রে এটা কার্যকরী হবে
হবে
হ্যাঁ ওই জন্যই ওরা বলছে ক্লাসিফিকেশন ক্রিয়েটার ক্লাসিফিকেশন derogation of Article 14. It is your case.
That is one point. Another is for PSC, madrasa, everywhere for the post of headmasters, same administrative post, almost same emoluments and benefits, everything, same post, but for them it is 45% or 40%. But for the same post under the same education department, same government, same nature of post, same pay for teachers for the SS through SSC, it is 50%. This is another element of discrimination.
But the West Bengal Coal Service Commission Act applicable to which school? Whether it's applicable to madrasa?
No, they are under Madrasa Service Commission. Those who are appointed through Madrasa Service Commission for the post of headmaster, they are not required to get 50%. Those who enter to the government schools through Public Service Commission, for them also it is not required. It is below 50%. But only for the teachers of government aided and sponsored schools, where they participate through the School Service Commission, for them it has been enhanced to 50%. So I tried to make out a case.
Amendment has been done.
Yes.
In exercise of the power, rule has been done, exercise of the power 17 of the Act.
Yes.
So the provision of the Act will applicable to those schools. Amendment will also
Yes, yes.
applicable to those schools.
Yes. Now, our point is that the post of headmaster is an administrative post. Though he takes classes, but principally and fundamentally it is an administrative post. He receives administrative allowances also for that. Now for post of administrative post, you are giving importance to academic qualification. Very well, you have the power to do it. But in the same state, under the same education department, for when there is a same nature of post, character of post, duty is similar, pay is also similar, for different headmasters, different requirement. That is objectionable according to the petitioners before your lordship, that there cannot be discrimination. Had the nature and character of the post were different, then I would not have made this submission. But when the post is same, merely because the nature of schools are different, though under the same umbrella of government of West Bengal, you cannot resort to an arbitrary classification by enhancing the qualification. Now, they came up with their contention that we want to maintain the academic excellence, for which we have enhanced it for academic excellence. Now, first of all, post of headmaster is essentially administrative post, unlike the post of assistant teachers. Though he takes classes, I'm not denying that. But if academic excellence is the issue, then you ought to have made it mandatory for PSC schools also. For madrasa also, you cannot say, no, I don't want to maintain academic excellence in madrasas or in government.
Why they have done it is not our lookout. Why they have done. What they have done, whether it is illegal or not.
That has been recorded in the impugned order. That is why I made this submission. And it is also contrary to NCT regulations.
NCT regulation have you annexed?
Yes, yes, all are there. I will be placing one by one after another. Because NCT regulation was not dealt with properly in my respectful submission subject to correction in the impugned order.
Yes, anything else?
Yes, yes. My lord, I need to show. My lord, kindly take the order, the interim order granted on the last occasion by the coordinate division bench, my lord.
How that will help you?
There is a proper discussion about the issue, my lord. I would draw your lordship's attention if your lordship kindly.
Interim order has marched with the final relief. Place there, yes. Show us what is the wrong in the order.
Was prima facie satisfied, the honorable division coordinate division bench is prima facie.
Whatever may be the finding, you are
Yes,
arguing on merit.
Very well.
Yes, you argue on merit.
Yes, yes, very well, my lord. My lord, kindly come to the NCT notification at page number 225 of volume 1.
नहीं ना तो
Yes.
Yes, page
225. 225 is the regulation. I'll take the bottom.
Yes.
These regulations may be called the National Council for Teacher Education, in bracket, determination of minimum qualifications for persons to be recruited as education teachers and physical education teachers in pre-primary, primary, upper primary, secondary, senior secondary, or intermediate schools or colleges, regulations 2014. Now, my lord, kindly see the next page 226, applicability. To whom it applies?
Yes.
These regulations shall be applicable for recruitment of teachers and physical education teachers in any recognized school imparting pre-primary, primary, upper primary, secondary, or senior secondary or intermediate schools or colleges imparting senior secondary education. Explanation. For the purpose of this regulation, the term school includes a school established, owned and controlled by the central government or the state government or a local authority, that is schools under PSC, Public Service Commission. Second, a school receiving aid or grants to meet whole or part of its expenses from the central government or the state government or a local authority, which is the present school under which I am. And thirdly, school not receiving any aid or grants to meet whole or part, that is, I'm not. So, my lord, kindly.
Where from do you get PSC?
No, this I'm saying government schools. Government schools in our state is
Yes.
Yes. So, therefore, my lord, for the pure government school also this applies, and for the aided schools and recognized school also this applies. Now, my lord, kindly come to the chart given at first schedule of page 226.
Page?
Page 226, first schedule.
Teacher.
This, the National Council for Teacher Education determination such and such regulation. Kindly see the chart given below. Serial number 4. Level, and the heading is minimum academic and professional qualifications. Kindly see secondary high school for class 9-10, graduate or postgraduate from recognized university with at least 50% marks in either graduation or post-graduation or its equivalent, and Bachelor of Education B.Ed from National Council for Teacher Education recognized institution, or page 227. That is 50% now, or B. Graduate, postgraduate.
Where did you get or?
Kindly see page 227 at the top, 227. Or B. Graduate or postgraduate from recognized university with at least 45% marks in either graduation or post-graduation or its equivalent, and Bachelor of Education B.Ed from National Council for Teacher Education recognized institution in accordance with the National Council for Teacher Education form of application for recognition. That is not applicable, just required. So, my lord, both 50% or 45% both are there as per NCT regulation. For candidate having either 50% or 45% are eligible as per NCT regulation.
Now, what is the addition in clause B? Clause 1 was postgraduate with 50%.
Yes.
And B.Ed. And in clause B, it is post-graduation with at least 45% and B.Ed. And any other condition?
No, that is what is written is regarding B.Ed, NCT has clarified that this kind of B.Eds are to be considered Bachelor of Education from NCT, National Council for Teacher Education.
That is also in the earlier clause.
Similar.
Then what is, what is the difference between A and B?
Difference is 50% and 45%, both.
Yes, yes.
Second is B.Ed has been explained. Kindly see B.Ed in page 227.
Someone 45% with training is compared to be equivalent with 50% and training. এতে বলছে 50% with training হতে হবে বিতে বলছে it may be 41% with training. But what is the distinction?
Graduate and postgraduate and Bachelor of Education.
ওটা ওখানেও আছে up to Bachelor of Education for Teacher Education recognized institute. এই clause-টা has been clause A. What has been added is a clarification in accordance with NCT form of application time limits that is separate and necessary. So what is the difference between A and B? Apart from ওটাকে না দিয়ে কোনো condition করাই নেই।
এইগুলো নেই।
না that ওটা তো রেগুলেশনটা না। In accordance with, where is this regulation of 2002 notified on 13th November?
Presently, I am not holding this notification. This is regarding B.Ed only. It has got no application in my case. It is regarding B.Ed, from where they would obtain B.Ed.
So the nature of B.Ed in clause B is the same as nature of B.Ed in clause A.
B.Ed has got no role to play.
We are asking you, in clause A, they are saying 50% plus training. And in clause B, they are saying 45% with training. Apart from that, any other condition is there in B?
No, my lord.
The only distinction is 50 and 45. Very good.
50 and 45. No.
Yes.
And it will be also.
And in the clause C, there is no requirement of any 4-year degree in BA, B.Ed, whatever marks you obtain, you are eligible. Very good.
So, my lord, both the conditions, 50% and 45%,
are there in NCT.
NCT or in either or. I can go with. Now, my lord, for reference, for I showed 9-10, for 11-12 is serial number 5, perimeteria, similar.
We need not go into.
We need not go there. Yes, ma'am. This is one. Now, my lord.
So you are saying there is no rationale between A and B. You are saying either A or B, but the qualification requirement in both are the same, 7 except 50% and 45%.
But if I have understood correctly, my humble submission is that 50% is also eligible, 45% is also eligible.
That is what we are saying.
Yes, that is my humble submission, my lord.
Yes.
Both are
Yes,
eligible.
anything else?
Yes, my lord. I'm just coming. My lord, kindly take, just give me a moment. My lord. Yes. My lord, kindly take the page number 161 of that volume itself.
What you are showing?
That public service commission requirement. That is below 50% public.
That is an admitted fact.
It's very well.
Why you are going?
Very well, my lord. Now, my lord,
What page did you say?
That is page 161,
Yeah.
173, and 176.
173 and
176.
very good.
161. That is Madrasa and Public Service Commission.
In all, it is 45%.
45% for Madrasa, 40% also.
Acha. In none, it is 50%.
None, it is 40%. Now, the second point, as it had fallen from my lord justice.
So your first argument is NCT permits 45%. And in government and non-government, state government, aided school, all are applicable.
Yes. Exactly.
But your second argument is that in case of government school, they are keeping it 45%.
45%.
In madrasa, it is 40%.
40%. Considering the nature of the post, there cannot be any discrimination on that. And that is an administrative post. Principally, fundamentally, it's an administrative post, where the role of academics plays.
Go one by one. Now, that was your first. Second argument is what you are saying, arguing?
That this is discriminatory, as a lordship.
That we understood.
Next is that, my lord, the post of headmaster is administrative in nature. Fundamentally administrative in nature, where the role of academics plays secondary.
Where from you are arguing this?
Post of
in support of that, do you want to show us any document?
No.
This is your submission.
Submission. This is a
Administrative post, and in such the qualification is not so to be granted weightage. 40% can do.
Yes, as per the NCT, that is why it has been kept, my lord. It is
very good. Now, what is your next argument?
Next argument is that, my lord, those who are in-service candidates,
they have been excluded.
They have
Proviso says it will not be applicable to them.
So the level playing field.
Yeah, just a moment.
In service means no, who have already joined as working as a headmaster.
Suppose
they are excluded.
They are also eligible to participate in the recruitment process, but
with 45%.
With 45%, with their previous qualification.
And they are doing working as
headmasters. Now it is destroying the level playing field. At the ground level, when there is a public recruitment, the ground level where there is a public recruitment, you are destroying the level playing field by giving the benefit to them and imposing higher marks on us.
Because of their past experience, they have worked as HMM.
Yes. In that case, my lord.
That is the reason for equilibrium of leveling the common field.
My respectful submission would be, if they have worked there, so the experience is to be taken into consideration as their headmastership. But that is static, as 10 years. If someone has there for 15 years as headmaster in another school, he will not get any benefit. He will only get the benefit of this reduction of 40.
You are not for them, so why you are breaking your head?
No, I am saying they have been allowed. We should not have been discriminated against them.
The victim of discriminatory.
I'm because they are being allowed just because they're headmasters. If they're headmasters, their 10% service is to be taken into consideration, which is the basic minimum requirement to participate in the recruitment process of headmasters. That is to be taken into consideration. Merely, suppose one headmaster is there for 15 years.
Yes. Next.
Headmaster's experience is not taken into account.
That's what I'm saying.
The assistant teachers 10 years.
No,
is
his
taken.
argument is those persons who entered with 45 on the dint of their.
Yes, that I have followed. And what fell from the court also I have followed, but he is trying to justify by bringing in the 10-year experience.
No, he's trying to differentiate that they will in their entire life they will not be required enhanced qualification of 50%. But as we are fresh entrants for the post of headmaster, you are creating this. That is the discrimination. Yes. Next, what is your argument?
Yes, my lord, kindly come to the report filed by the commission at page number 295 of volume 2.
Page
295 of volume 2.
Yes.
My lord, this is the report filed by the commission. And they have taken a point. I draw your lordship's kind attention to page number 297 at paragraph 7.
297. This is a affidavit by commission.
Commission.
Yes.
Kindly see the point they have taken, that only 2 persons have been qualified.
Where?
Page 297. Paragraph
Yes.
7.
Place it.
Yes, that from the said report. Yes, that from the said report as relied upon by the learned government pleader, it appears that total 65 persons who are writ petitioners of different writ petitions and who possess less than 50% marks in their respective master's degree.
Only 2 emerged to be successful.
2 only emerged to be successful. One is before your lordship, that your lordship is hearing the paper book. That is of the first candidate, Pranoti. Pranoti is successful.
And other one is another.
Tondra, I am not present in Tondra.
No. Then who is there in the other writ petitions?
I am there. From
in the other writ petitions, that second person is not there. Very good. Tondra Rai is not there.
I'm not.
So you are there are only 2 successful. Yes.
According to them.
Yes.
2. So rest are not. This is one. Now, my lord, kindly come to a response which will appear from page 304 of the same. I have explained that why we have been successful because of the rank list that I will show.
Will that be too much relevant? Because what we are considering is the discrimination. If we succeed, if you succeed that it is discriminatory, then we strike down that one. So the what will be the effect? Effect will be effect will be on the persons who pursuant to interim orders have got the rank. They are saying it is 2. You are saying no, everybody has. That is your justification.
Yes.
So why do you want to dwell on that? Because in this writ petition, we are not passing any order that you appoint them. We will say if it is discriminatory, we will declare it is discriminatory. So their participation will be legalized. Now your appointment will be how you have in the panel or not in the panel. They are giving wrong report. We are not concerned with that.
The difficulty.
We need not answer that issue, no?
Difficulty is it is on records.
Very good. We will clarify that. That will be open to you to be agitated. Suppose we hold in your favor. Then what? Those persons who have participated, they all become eligible. Now after eligibility comes whether selected or not. In respect of which there is a dispute. We will leave that problem open for you. No problem.
I appreciate one thing. I understood following from your lordship. I bow down to lordship's observation. Only one thing. Since they have taken this point and your lordship is keeping it open. That you can.
No, we are interacting with you. So to cut it short.
Yes. So since
because otherwise you are giving us a more task that you ascertain also whether I have been rightly excluded or included. those terms.
I understand, my lord. Since
Anyway, you show us your defense. We will go through it
since
wanting
they
to
have
place.
taken the
Make yourself short, Mr. Lady. Yes, page.
yes, page 310. Kindly come, my lord. Page 310.
So you're 304, you said.
304. This is my submission, which in the amendment in the.
What was that portion? You have dealt with that
I've dealt
paragraph,
with-
no?
I've dealt with, dealt with that paragraph.
That is which paragraph? I say page paragraph 6.
Page 304. There's paragraph 7.
Paragraph 7. Yes, yes.
295.7. In 304.
307, you are answering that. Paragraph 6.
Yes. From 304 onwards, from paragraph B onwards, I have mentioned in reference to the separate repetition, certain ranks kept on missing. Why?
No, we will not go into that issue.
Very well.
If we decide in your favor, we will say that they were all eligible and they have participated by virtue of court's order. Now, whether they will be recommended or not be recommended will be depending upon their success in the test. Depending upon their success in this test, which is a gray area, which you say that no, not two, plenty have got it. You are suppressing that. That will be open.
If your lordship holds that, kindly keep that portion open.
Certainly.
Yes.
So,
If your lordship doesn't want to go into that, kindly keeps that.
no, we doesn't want. If you argue, we have to deal with it. But we are asking asking what is your stand to that. I think that
Only
will.
because commission has taken this point specifically on.
Acha, show us. What you want to show.
Yes. My lord. Otherwise, I would not have shown to your lordship.
Yes.
Take it. I'm just, my lord, directly showing from the list itself.
Yes.
The page 310, kindly come, my lord. 310.
According to you, 21 candidates became successful. That is paragraph 6307.
Yes.
And this, what is the total quantum of writ petitioners in these matters?
5 possible.
All of them participated by virtue of interim order.
My lord, I do not have the information because I am representing 16 candidates.
16 candidates in WP, in which W?
Total in all this one.
In different writ petitions.
Different writ petitions, single impugned order.
You are representing whom?
I am representing, my lord.
You make a chart through your junior.
I have made it.
দেখি
ওটা দাও।
আমাকে এক কপি দে।
এটা আমি রিটেন নোটস অফ আর্গুমেন্ট দিচ্ছি স্যার। I'm handing over to them also. And this is another chart.
This is a written note of argument which you have.
Yes, this is because last occasion lordship wanted to say how much they obtained. So I give, and by now, my lord, they all have, most of them have, out of 16, 14 have obtained fresh master's degree over 50% subsequently. Lordship wanted to.
And very good. Go and participate in the next process. Finished.
One would be retiring at 60, will be touching 60. This lady will touch 60 very soon. So it will not be possible, my lord. Very difficult. Your lordship kindly see.
No, whom are you representing? These 7 persons?
These 7 কেন 16 হবে তো। These 7 appeals, amongst them there are more than one petition.
Here there are 15.
Yes.
You are representing these persons.
These persons.
They are parties in different writ petitions.
Different writ petitions.
And the other writ petitioners are not contesting. Nobody else is interested.
I know one is being represented by Mr. Jahan.
I don't know.
Yes, I know only that much. I do not know the rest. I am only for this 15.
Yes, very good, very good. Yeah. So 21 out of 21, those 21 selected, you are representing 15. Yes, very good.
Kindly come to page 310 for once. Just to address their point, they have put out of this.
Answer করবো level playing field ছিল ডিসক্রিমিনেশন হলে তো এটা এন্টাইটেলড হয়ে গেল, পরীক্ষার যে রেজাল্ট হয়েছে তাই পাবে। Whatever we do, সেটা বলছি না, বলছি দেখো এদের জন্য hundred and 13 is missing, 821 is missing.
Take 414 for once. 414.
Page 414. আবার কিসে যাচ্ছে?
No, I'm just justifying their stand. My stand against their stand. 414.
414. Yes.
Kindly see the remarks. We will abide by order of the Honorable High Court of Calcutta. This is a reason for keeping those ranks suspended, if I say. And last page I would show, page 224 of volume 1. Volume 1, page 224. It is not the case that
Page
224 of volume 1.
Yes.
But kindly see, this is a notification dated 22nd of January.
Sharpener আছে কি দাও তুই? Page
224.
224
of volume 1.
Two 224.
224.
Yes, what you are saying?
Yes, this is of 22nd of January 2019. This is notified for all concerned that ranks which are shown missing in the merit list in connection with first SLST 2017 published on 18th of January.
Kept on hold in compliance.
Compliance with the order. So missing, our case is that it is not, we were not. Then for what reason those ranks were kept in abeyance?
Yes.
This is all. And lastly, my lord, I have handed over. By now, out of 15, 13 have obtained master's degree subsequently.
Not required.
In case today, if your lordship considering, they have in different subjects, they have enhanced their qualification much above 50% today. I've handed over the list also, apart from 2 candidates.
Okay, so lots of arguments.
এটা একটা লিস্ট বানিয়ে দিয়েছি স্যার, এটা দিয়ে দিচ্ছি। They have now, since 16 posts were kept vacant, just to assist your lordship.
Yes.
That today, if your lordship looks at
Till that 16 posts kept vacant.
16 posts vacant.
Where is that order for keeping the post vacant?
Page 420 of volume number 2. Starting from page 421.
আলপিন আছে নাকি? কিংবা স্টেপলার আছে? স্টেপল করে দাও। হ্যাঁ ওই যে ও যেটা রিটেন আর্গুমেন্টটা দিয়ে দিয়েছে।
But here, able person secured more than 50%. Able person, more than 50.
No,
Mohammad Ajam Ali, 60.125.
yes, 61.
Thereafter, 61, okay, 61.
Yes.
Subhash Chandra Bose,
72.
72.
Then
Thereafter, Ashok Kumar বিশ্বাস, 79.
79.
Prasanto Shah, 74.
74. 65.
Sutapa Ghosh, 65. Then you come to Ashok Alok Kumar Jana,
83%.
83, and
Dibyendu
Dibyendu
Purkai.
Purkai, 60. So 1, 2, 3, 4, 5, 6, 7.
কয়েকজন
Yes.
yes anything else Mr. Laidi?
The order you wanted, also wanted to see.
Yes, yes,
Page
page
4 to 1, starting from 4 to 1.
421
দেখি interim order. Interim order. Interim order tentative. All observations are tentative.
Yes, yes.
এখন
Observation has been made. Primary.
so any further selection process conducted
No.
after in your participation?
আর কিছু হয়নি তো? No.
You participated in which year?
This is 70.
2007. Thank you. Yes.
So the state may answer first because the
No,
rule
no,
is.
you are first. We will state if they don't want, they won't argue. What is your stand, Dr. Patro? You make it clear.
My lord, before the single bench, state had argued first and we had already adopted their arguments. We did not tender separate arguments.
Then you can make a summarization of that. What was the
My
argument?
lord, my lord. First, as far as the commission is concerned, our role is not identical to that of the state. Whatever the rule comes, we implement it. We neither frame the rules, we are bound by the rules rather. Now, what my learned friend has argued, it is very clear. There is no dispute on that count, that first the rule was framed in 2016, after which it was amended in 2017, and then the advertisement notification was issued. So at the time of making their online applications, they were aware of the amendment. They were,
Yes, there is no dispute.
yes, there is no dispute here.
That is why they, unless they would have been aware, why would they have approached the court?
Yes.
Because your advertisement was prior to the amendment.
Yes, but they participated.
No, sorry. Your advertisement was when?
My lord, I'm telling you. The
advertisement is after.
It was the 3 dates. The
advertisement was on 12th of June 2017.
So in the 12th of June, in the advertisement, the amended qualification was incorporated.
Yes.
There is no dispute. They were aware.
Yes. So they were aware.
What is the date you said, Mr. Dr. Batra?
12th June 2017.
12th June 2017. And amendment was? Page 143 was?
On 24th March 2017.
24th March. Yes. In fact, you have nothing more to say now.
No, technically I don't. If I
adopting the submissions.
Yes, if I say beyond this, I am bound by the rules. I have followed the rules.
Bound by the rules.
Now, what other orders were passed by court, keeping the vacancies, etc., that we have done. Initially, there were 65 candidates. The court wanted to know how many of the candidates are above the cutoff. We had filed an affidavit, which my learned friend has pointed out, that 2 candidates were above the cutoff. So the remaining 63, even if they succeed, they will not get a chance to participate.
Total was how many candidates?
65 candidates were before the court.
In various writ petitions?
Yes.
Total 65.
Yes, only 2 were above their respective cutoff marks. Now, after passing of the order, after passing of the order of the learned single judge, rejecting their contentions, only one has come up in appeal. So as far as
the others, it will be dismissed.
Yes.
That is your contention.
Yes, or else, unless they succeed in whatever arguments they are tendering.
No, if the writ petition was heard analogously, na?
Yes, yes.
So even if some does not represent, all will be bound by our verdict. If they get benefit, they will also get benefit. Because the writ court order is not in their favor. So today, if we declared that it was discriminatory, in that case, our declaration will
The order will be there. Now, whether they want to come forward and take the benefit of the order, that is for them.
That will apply to them also.
Yes,
That
yes.
case
If your lordship hold that 45 can also be considered, 45 should have been considered, then it will apply to them also, at least those who were in the writ petitions.
All right. Any judgment, Dr. Patro?
My lord.
Yes, Mr. Dhol.
Only one thing may I submit, though it will be actually for the state to argue. My learned friend was relying upon the NCT regulation, where there was clause A, clause B. Clause A saying 50%, clause B saying 45%. 45% provided you have your B.Ed degree under the rule which is notified there. That does not either
that under those rules is not there in clause A.
Yes.
But what is the difference?
That requires to be seen. That rule my learned friend has not brought. I have also not. I do not have it. But that is the reason why the relaxation. Or else they would not need to.
Tell the page NCT regulation.
227.
227.
226.
226.
We are also seeking such qualification. What is the difference between A
and B?
A and B. 4A, got it? 4A, look, graduate, postgraduate with 50%.
Yes.
And Bachelor of Education from National Council for Teacher Education recognized institution. Stop. Here also 45% and Bachelor Education. Now from such and such.
In accordance with such and such rules.
A regulation, two regulation has been deferred.
Yes.
So what is the difference between A and B?
That requires to be looked into.
And the bachelor education degree.
Only if the B.Ed is of this nature will you get the relaxation, that is 45.
What can be the rationale behind that?
Unless the
NCT is not a party, na?
No.
NCT is not a party.
It's not a party.
Unless then have you got these two notifications?
Not right now. I do not have, because it was not discussed in the single bench's order. It was not.
No, my brother has raised a query. You better collect these two regulations. 13 November 2002 and 10 December 2007. Yes, regarding NCT, you want to give any input?
No, only this I was pointing out that it cannot be
B.Ed
50 and 45 for the same thing. So 50 if it is from an NCT recognized institution, that we have all understood. 45 if the B.Ed is of a particular nature which is described in clause B, this requires to be looked at. I am not in a position myself also to, but this much is clear that the B.Eds are the reason for which they distinguish it.
Now what is different here? Relaxation of 5% marks.
Yes, that has to be seen.
Why?
That has to be. This is possibly because this purely speculative.
This B.Ed will not automatically enhance my master degree qualification. It will, this B.Ed will not make
possibly in 2002. Possibly in 2002, the master degrees 45 was the required pass mark. Subsequently, it became 50%. These things are also other issues which are interfering with the entire At one point of time, master degree, the pass marks were 45. As on date, pass marks are all 50%.
So you have not showed us what is the reasoning of the single judge refusing your prayer. That must have dealt with NCT also.
That has not been dealt. This NCT regulation has not been dealt in its entirety.
So that ought to have been your argument.
And my lord, in my instruction is that there is no such difference.
In NCT, 45%, the candidates seeking 45%, along with B.Ed, in accordance with this regulation, 2002 and 2007. That is, who have completed B.Ed as per this regulation, they are only entitled to get relaxation of 5% marks.
It's not stated in the recruitment notification or rule that specific nature of B.Ed will be getting appointment with this. So there is no such whisper in the recruitment rules. My instruction is, my lord, that this does not bar me from availing this 45% requirement.
Now, if my learned friend's client's B.Ed is not of this nature, then naturally he will be excluded. If he wants the benefit of clause B, maybe my rule does not provide. My rule says 50%, whoever has a B.Ed from an NCT regulation. Now he is saying that the NCT, which is the guiding rules, that says something different. He has to show that his clients fall within this different category. Then that 45, your lordship, might.
NCT submission was not reflected in the advertisement that it will be bound by. Was there any indication that NCT guideline will be
B.Ed? Only B.Ed, my lord. Page 43. Not in the advertisement also. I'm placing it here.
The NCT guidelines binding upon all schools. On the earlier date, we are thinking about the school. Lastly, we found that all schools.
Regulation 2.
That means a school includes all sorts of schools.
All sorts of schools. All over.
Even the schools which is manned by the teacher appointed by the commission.
Now the state has admitted that NCT is binding. So having said so, they have to explain this then. State বলতে NCT অনুযায়ী আমরা করেছি। Has to be.
Yes, Mr. Dhol.
Mr. Dhol.
In this matter, for this because it was I was
Tell us the date. We will finish it off. We will not keep it pending. You complete your argument. Any written note you want to file, you file. We cannot adjourn, sir. If you want to file, you tell us the date when your advocate general will come. But we make it clear, we will not give any further adjournment for your advocate general to come. Because he is busy in many matters. It is almost an impossibility for him to attend all courts. We also faced same type of problem.
we do,
And that too in this court itself.
but taking up matters here, my lord, it is not that I didn't argue before your lordship, my lord. The problem is, my lord, we have, my lord, instruction, my lord, that we should be led by AG. My lord, I will talk to
Then
him.
talk with the AG.
Yes.
Then talk with the AG, take his permission. That court is insisting it will
Yes.
not give any further adjournment. What am I to do?
Yes.
I will take that.
You also go study the brief and
Hello.
come.
And lastly, say that court will not permit, I will not grant any more adjournment. In that circumstance, I am to argue. Then he will say, you argue. Then
Tell us when we are coming. Tell us, you tell the date, we will fix it.
Page 49, if I may, just once, I trouble your lordship once. Page 49. the query may be met. My lord, page 49. Regarding the kindly see the schedule 1, master's degree essential, master's degree.
Yes.
My lord, it only speaks of B.Ed.
Clause A, the language is identical to
Yes.
clause A.
They omit clause B completely. They do not refer to clause B. It is not there. That is why it was challenged. This is not there because 45 is also eligible. I just need to ascertain before a lot.
No, that is if NCT is adopted in totality by the state.
That is the stand, my learned.
That may be the stand. If that is the stand, then apparently it appears that when you are taking that stand on the rudiments of the reasoning that NCT is my guideline, then it is incumbent upon you to explain that why you are incorporating clause A qualification and not clause B, which is also permissible in terms of NCT. That is for them to justify.
Justify, yes.
But you have to bring those two notifications. Whether state brings or not, that is separate issue. And you argued one administrative post where from in support of that what you have.
I'll come.
What you have.
Not here, I'll come with that.
Aber come with that. No further document inclusion anything. You have failed to show us any document in support of your contention that HM is an administrative
There are
post.
notifications.
Show us.
Not
Show us.
with me right now.
There is no notification.
It is an administrative post.
That is an argument of lawyers.
My lord notes that it is an administrative post, my lord, mostly.
No.
They get an administrative allowance which the assistant teachers don't get.
That is not the case made up.
I'm trying to ascertain.
That is a different aspect. That is not a ground in the writ
Yes,
petition.
I'm just trying to make out a case.
Another, you cannot make out a case in appeal.
No, I'm not. I'm just saying.
Show us that administrative post you have stated in writ petition. What is the reply to that? We will consider. Otherwise, we will say that no further next.
For
You have
discharging additional duty, a certain allowance is given. Additional administrative duty.
In my respectful submission.
Actually, he is teacher, headmaster.
Respectful submission, my lord, it is the other way around. He is the headmaster because that is why his recruitment is different.
That is why we are saying this is lawyer's argument. Headmaster is the teacher. For administrative convenience, like the High Court judges, we are sitting and hearing you, but we have administrative duties also.
Yes.
So then please do not say that this court is also. You will go to that extent. দুদিন বাদে বলবে High Court
No.
হ্যাঁ
No, not that. Then for what?
Chairman of DLS
is the
district judge.
Yes.
And administrative allowance is given. I don't want to mention.
Not on that.
So your argument on that count fails.
Very well, I'll come.
That
show to you.
That issue is not. We are only disturbed by this
NCT
commission and the
and the discrimination part, my lord. These others, Public Service Commission, in the same state, same post, same financial benefit.
Purpose is to win the case.
Yes.
Win on any ground.
Any ground.
That is your argument.
Yes. Just keeping my avenues open so that if one fails, the other helps me.
What we are
কবে করবে ফাইনাল করো না এবারে
because the point really to your senior I have told
এই রিটেন নোটস অফ আর্গুমেন্টটা দিই আচ্ছা নেই
ট্যাবে আছে
আমি ট্যাব ইউজ করি
The B.Ed is required in the relevant academic session. Eligibility, B.Ed is to be in the relevant academic session. And that particular thing is also incorporated in the advertisement also. But 45% NCT, that is with regard to 2002, those B.Ed institution, those Malot completed those B.Ed in pursuant to 2002 Malot procedure and norms, there is a regulation.
Yes.
Because of that, if that be so, our requirement is relevant academic session. The B.Ed should be 45% has been given, followed with a inclusion that
that B.Ed of particular 2002 regulation, those institutions who had Malota imparted B.Ed in 2002 regulation, that will be Malota 45% has been incorporated. Malota, if that is so, Malota,
Why you are taking it? What is the rationale behind it?
Malota, in that case, Malota, if the relevant academic session is the criteria, then 50% is the Malota.
Relevant
Yes,
academic-
I consider page 14.
relevant academic session, show it us in NCT.
NCT তে কোথায় আছে?
Anywhere you should.
But if that Malota, then the first part portion is applicable.
You are saying, you are trying to make out a case that NCT guideline has said the right thing. It has lowered the threshold qualification since he is a B.Ed holder under 2002 regulation.
2002 regulation,
then you have to justify that why that B.Ed is more valuable than the B.Ed clause A, or it is less valuable. Some reason it must come.
That is the minimum qualification. That is the minimum qualification, and we are seeking 50% because we are given Malota specific thing that the relevant academic qualification, relevant academic year is the criteria for B.Ed, and 45% is only Malota limited to those person in 2002. Malota, then in that event the first clause of
the 2002 circular, what does it say? What regulation it says in respect of a B.Ed of a regulation of 2002 and a B.Ed, there are terms of clause.
there is
Come to NCT. NCT clause says these first three lines have been quoted in clause B, page 226. Bottom, see those three lines.
the very first, the very first Malota requirement is 50%, and the B.Ed from National Council for Teacher Education recognized history.
This has been
the very first.
This has been typed and incorporated in clause. Not like same.
But the B.Ed only that is 45% and the B.Ed of that particular year. And our requirement is the B.Ed when the advertisement is
of that particular year. Where do you get?
Malota
And Bachelor of Education from NCERT.
Our rule. This is our rule. Our rule which requires the B.Ed of the particular relevant academic session. That is our rule.
That is, you have shown at a party of that academic
Session when the advertisement is going to be issued. That particular academic session. That is the rule.
No. Cannot be. Then 10 years experience of a teacher, unless he gets 10 years experience, he cannot participate in the recruitment. So his B.Ed has to be long back. This is submission from the bar. That academic session. How can it be from that academic session?
So you lost.
But any day after four, from fourth.
আবার আমাকে আর্গু করতে হবে শুরু থেকে।
আরে না
Basis. Yeah. Not much instruction also for this. আরে মেটেরিয়াল ইনস্ট্রাকশন নিয়েছিলাম, বুঝতে পারছো না এতবার করে করতে।
তুমি বুঝতে পারছো আমারও ব্যাপার।
আরে একটা দিন চেয়ে রে, নাহলে এই বিষয়ে কথা বলতে পারবি না।
আরে কালকে করো তাহলে।
আরে আগের দিন কনফারেন্স হয়ে গেছে,
আগের দিন 2 ঘন্টা আর্গুমেন্ট।
The regulation you read on that date we give further.
No, on that day I'll come. I'll come with the regulation.
Mr. Dhol, if the
My lord.
not possible.
No, my lord, I will
to
talk.
argue and finish it.
I will talk.
একটা